Court officer, sir. Court officer. ಕೋರ್ಟ್ ಆಫೀಸರ್, ನಮ್ಮ ವಾಯ್ಸ್ ಕೇಳ್ತೈತಾ? ಸರ್ ಎಷ್ಟೋ ಸರಿ ಲಾಗಿನ್ ಮಾಡ್ಬಿಟ್ಟು ನಾವು ಹ್ಯಾಂಡ್ ರೈಸ್
ಕೇಳಿಸ್ತಾ
ಮಾಡಿದ್ರು
ಇದೆ.
ಲಾಗಿನ್ ಮಾಡಲ್ಲ. ಮೊನ್ನೆನೂ ಹಂಗೆ ಆಯ್ತು, ಹ್ಯಾಂಡ್ ರೈಸ್ ಮಾಡಿದ್ರು ಲಾಗಿನ್ ಆಗಿಲ್ಲ. ಯಾಕೆ ಸರ್ ಆತರ?
ಕೇಳಿಸ್ತಾ ಇದೆ, ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇದೆ.
ಓಕೆ ಓಕೆ, ಹ್ಯಾಂಡ್ ರೈಸ್ ಮಾಡಿದ್ರು ನಮ್ಗೆ ಮ್ಯೂಟ್ ಮಾಡ್ಬಿಟ್ರೆ,
ಹಾ.
ಹ್ಯಾಂಡ್ ರೈಸ್ ಮಾಡಿದ್ರೇನು ಎಷ್ಟು ಸರಿ ಓಪನ್ ಇದು ಲಾಗಿನ್ ಮಾಡಲ್ಲ ನಮ್ಗೆ. ಅದೇನು ಗೊತ್ತಿಲ್ಲ, ಮೊನ್ನೆನೂ ಹಂಗೆ ಆಗಿತ್ತು. ಹ್ಯಾಂಡ್ ರೈಸ್ ಮಾಡ್ತಾ ಇರ್ತೀವಿ, ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೀವಿ ಚಾಟ್ ಅಲ್ಲಿ ರಿಕ್ವೆಸ್ಟ್ ಅಂತ. ಅದನ್ನ
ಸರಿ
ಸ್ವಲ್ಪ
ಸರ್,
ಈ
ಸರಿ
ಕಡೆ
ಸರ್,
ಗಮನ
ನೋಡೋಣ.
ಕೊಡ್ಬೇಕು ಸರ್ ನೀವು
ಟೆಕ್ನಿಕಲ್ ಅವ್ರು
ದಯವಿಟ್ಟು. ಓಕೆ
ಹೇಳ್ತೀನಿ ಸರ್, ಹೇಳ್ತೀನಿ, ಮಾಡೋಣ.
ಓಕೆ.
ಎಷ್ಟು ಇಡ್ತೀರಿ? ಎಲ್ಲಿ ನಾ ಯಾಕಲ್ಲ ಎಲ್ಲೆಲ್ಲ ನೋಡ್ಕೊಂಡು ಎಲ್ಲಿ ಯಾವ ನನ್ನ ಟೇಬಲ್ ಮೇಲೆ ಐತೆ. Fresh matter, matter. Fresh matter. Get to the court office. Fresh matter ಕೊಡಿ. Please call the list.
Seek my lord's leave to mention one pending matter. Writ petition, my lord, regarding change of name of a student, school going student, my lord, 6, 7, 8 years old student. Father is working in the, my lord, army. He gets transferred, my lord. Now the school authorities are, my lord, not issuing the necessary documents because of this issue, my lord. This is a straightaway covered judgment, my lord, of this one.
When was it filed?
My lord, it is filed and notice is issued in the last year, 2025. Covered matter. This honorable court on the direct point has rendered a judgment.
Is this matter on Thursday?
One matter.
May I request on Tuesday, my lord, if it could be, please.
Yes.
On GMCPC matter, Your Worship, sir. On writ petition GMCPC matter, the petitioner had filed an amendment of plaint, Your Worship. Application came to be rejected.
When was it rejected?
It was rejected long back, Your Worship, sir, in the year 2024 itself. And this honorable court had granted interim order of stay. Suit has been stayed, Your Worship, sir. Now, final order, sir.
File the vacate.
Please, Your Worship.
When did you file the vacate?
I am for the petitioner, Your Worship, sir. Interim order was granted in favor of me, Your Worship, sir.
So you want the
Suit has been stayed, Your Worship, sir.
your suit?
Please.
List on 24th of February.
24.
Yes.
On CPC matter, madam.
On February, Your Worship, sir.
Not possible to take up now. Yes.
On CPC matter, madam. What has happened, madam? Earlier, this court has issued a notice that section 10 application has been rejected. That is, my lord, same persons have filed different suits when the subject matter is same.
Which year is the writ petition?
That's 2025. But now, my lord, what has happened? Which the suit I am seeking for stay that has been proceeded for further. It is, my lord, under section 10, it is not permissible. That application has to be, my lord, considered. May I seek, my lord, Tuesday, I will convince, my lord, because, my lord,
Not possible. Thursday.
because what has happened, my lord,
Tuesday not possible.
same property,
Tuesday not possible. Court is not sitting on Tuesday.
any date in the.
Thursday.
Please.
Yes.
Madam,
next.
one matter for
My
DIT
lords,
matter.
one
my lords.
online
The proclamation
submission.
issued by the proclamation notice issued by the respondent number 5, my lords. Auction is dated 3/2/2026, my lords.
Yes, it will come. Fresh matter. Give
Fresh
it-
matter, my lords.
Give it. Give it.
My
to the
lords,
court.
one submission
Yes.
online, my
Yes.
lordship. My lordship, this is from the Bangalore principal bench. This is about the child custody case, my lordship. It's a part heard case, and there is a stay on some part of custody which is yet to be decided, my lordship. Kindly, the last hearing was on 17th of December, more than a month ago, my lordship.
When was it posted? When is it directed to be listed?
No date was given, my lordship. Subsequent new developments have happened, and some.
You make a mention on Friday and Saturday. I'm sitting at Bangalore. Then you make a mention. I'll take it up on Saturday.
Much obliged, my lord.
Yes. Call the list.
Page wise adjournments. Page number 7, seal number 24 to 28. Page number 8, seal number 29 to 36.
Serial number 29, madam.
29.
29.
Harish,
There
yes,
is-
my
Yes, madam. There is a, the connected matter is the wrongly connected matter. That shall be
Connected matter?
deleted. As in the MFA 100,104,4496 of 25 is the wrongly connected matter.
It has to be dealing.
Yes, ma'am.
Then what is a connected matter?
Connected matter.
Take that. It is submitted that the MFA number 104496 is not connected with this appeal, dealing the same list along with so and so. Take that. Next week. Yes.
page number 9, seal number 37 to 42. Page number 10, seal number 43 to 49. Page number 11, seal number 50 to 55. Page number 12, seal number 56 to 59.
57, my lords.
Yes.
But I am for the petitioner. This matter was listed on 20th, my lords. The cavator's name was not shown. My lords directed to show his name and post it today. But however, it is posted in B group, my lord. It has not been heard and notice is not yet formally issued. It may be taken in preliminary hearing, my lords.
No, it will reach today.
Today,
I'll
please.
complete it.
Since it is a
I'll
half day,
complete-
my lord,
I'll complete the list.
Please, please.
Yes.
List number 1 for discussion, seal number 1. Uday Shankar Sindhe. Uday Shankar Sindhe. List 1, seal number 1.
As there was no representation on behalf of the petitioner, on 21/1/2026. The matter was directed to be listed for dismissal today. Today also, there is no representation on behalf of the petitioner. It appears that the petitioner is not interested to prosecute the matter. Accordingly, dismissed for non-prosecution.
Seal number 2, Sirajuddin Ahmad, AGA.
My lords, I apply for the petitioner, my lords.
Yes.
My lords, this petition is filed seeking grant of parole for the petitioner's son, my lords. The petitioner's son is in the custody since 6.5 years, my lords. On account of the illness of the petitioner, he is seeking the release of parole.
Have you submitted, have a representation been given to the jail authorities?
Yes, my lord. Yes, my lord. The representation is at Annexure B, page number 60, my lords.
Page number?
60, my lords. It's under Form 9, my lords.
Then what happened after that?
My lords, page number 64, they have rejected generally, my lords, that the police has generally failed. The police has
Order is not passed, Your
rejected.
Lordship. Endorsement has been issued.
That is the endorsement, my lords.
At page 62.
Please, Your Lordship. You have asked for parole, Your Lordship. The same has been rejected as per the contention because he wanted to take care of father's health, Your Lordship. As after inquiry, they came to know that his wife and child is there to take care of father. So on that ground, Your Lordship, his application is rejected.
No, you are saying that they have not, this is not an order.
No, it is an endorsement, Your Lordship. They have issued. Himbaraha.
No, whatever it is,
Please,
but
Your Lordship.
ultimately they said they have considered and rejected.
Rejected.
So this is an order.
Please, Your
So
Lordship.
how, you please read it and tell the court what exactly. this is.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಕಾರಾಗೃಹದಲ್ಲಿ ಜೀವಾವಧಿ ಶಿಕ್ಷೆ ಅನುಭವಿಸುತ್ತಿರುವ ಶಿಕ್ಷಾಬಂದಿ ಸೊ ಅಂಡ್ ಸೊ ಆದ ನಿಮಗೆ ತಿಳಿಸುವುದೇನೆಂದ್ರೆ ಉಲ್ಲೇಖ 1 ದಟ್ ಈಸ್ 1 ಲೋಡ್ಶಿಪ್ ಫಸ್ಟ್ ನಿಮ್ಮ ತಂದೆ ಅನಾರೋಗ್ಯದ ಕಾರಣ ಆರೈಕೆ ಮಾಡಿ ಬರಲು 30 ದಿನಗಳ ಸಾಮಾನ್ಯ ಪರೋಲ್ ರಜೆ ಕೋರಿ ಸಲ್ಲಿಸಿದ್ದ ನಿಮ್ಮ ಪರೋಲ್ ಅರ್ಜಿಯನ್ನು ಉಲ್ಲೇಖ 3ರ ಪೊಲೀಸ್ ಅಧೀಕ್ಷಕರು ರಾಯಚೂರು ಜಿಲ್ಲೆ ರಾಯಚೂರು ಅವರ ವರದಿ ಮೇರೆಗೆ ತಿರಸ್ಕರಿಸಿ ಉಲ್ಲೇಖ 3ರ ಪತ್ರಕ್ಕೆ ಲಗತ್ತಿಸಿದೆ. We have rejected your as per the report submitted by the officer, Your Lordship, page number 62.
What is the report?
Report says, Your Lordship, page number 63. After visiting their house, Your Lordship, they found that somebody, his wife and child is there to look after his father, the victim's convicted father, Your Lordship. So what he is seeking to take care of the child, take care of the father's health, Your Lordship, he wanted to go for parole. But as somebody is there to look after, that is the reason we have rejected his claim, Your Lordship.
My lords, my submission is that, my lord, earlier also he was granted parole, but he never misused the liberty which was granted to him by this honorable court. He was granted for a period of 90
That
days.
is not the ground for granting parole.
My lords, my lords, because I am the son, and though there my mother is there to take care, but at this stage, and because I need to go to the house, and also there are so many things where I can be granted parole, my lords. I have to maintain the social ties in order to keep family relationship. And due to long stress also I can be granted parole. I am seeking only mercy of this parole.
302 offenses under 302.
Yes, my lord.
Not for these kind of offenses.
My lords, earlier also this honorable court has granted, my lords, but I returned it, my lords.
When was
I
the parole
returned.
last time?
Last time is on the 14th November 2024, my lords, at page number 55. The order of this honorable court, my lords, my mother has sought, the convict's mother has sought for parole,
Where
my
is
lords.
that order?
My lord, at page number 55, my lord.
starts, Your Lordship.
Starts, my lord.
Unfortunately, these are not the grounds for granting parole in these kind of cases.
My lords, in several cases, this honorable court has granted, my lords, because, my lords, the
But
convict is a
that is the whole difficulty of this court also, because earlier similar orders are passed, everybody wants a similar order. In order to be passed, it should be as per, as in consonance with some section, some rule, some order.
Yes, my lord.
These kind of grounds cannot be the grounds for granting parole.
My
That
lords,
too in
there are 12.
offenses like this.
My lords, your lordship may consider that there are 12 grounds, my lords, in the prison manual, my lords, where he can be granted, when the prisoner can be granted parole, my lords, which I have mentioned in para 16 of page number 8, my lords.
Lordship, Rule 191, there are some grounds, Your Lordship, wherein parole can be granted. One of the ground, Your Lordship, when the life imprisonment or death sentence is there cannot be given. In the present case also, Your Lordship, 302 is there, life imprisonment. So,
But at least
Life
in one
imprisonment.
order, the state has filed a writ appeal.
No, my lords.
What is the reason in this case? The petitioner's son has been convicted so and so,
please, Your Lordship.
suffering from type 2 diabetes.
They have stated, Your Lordship, but in page number 63.
It is granted on that ground, type 2 diabetes. In a case of 302 parole. You can understand there are medical reasons or some other reasons which are not. Why should, if that is okay, every 6 months they should be sent on parole. Then there is no point in convicting them, giving them life imprisonment, imposing the sentence.
Not in every case they can be granted for every 6 months, my lords. Only, my lords, even my lords, my lordship may kindly see at page number 67. Page number 67 is the nominal roll, my lords. And at column number 12, my lords, my conduct in the prison is satisfied, my lords.
That in WP number 30464 of 2024, a coordinate bench of this court by order dated 14th November 2024 has granted parole to the petitioner. The order that is passed on extract that order. Land Council submits that the court in the earlier order, citing the reason that the petitioner's mother is suffering from type 2 diabetes, hypertension, he need to support her mother, and the son has served more than 5 years of sentence and granted the parole. It is submitted that, as in the light of the order that is passed by a coordinate bench of this court, already is entitled for an order, and the jail authorities, without considering the case of the petitioner, has rejected the same. In the light of the order dated 14 November 2024, the writ petition is allowed. Whatever are the operative portion of it should pass. Yes.
Oblige, my lords.
Order submitted, serial number 3. Same Dharwad, H. Bagi.
Please, my lords, I appeal for respond number 1, my lords. I filed a memo for, my lords, for time being return of LCR for withdrawal of amount, my lords.
The office is directed to return the TCR for the purpose of the respondent withdrawing the amount. Once the amount is withdrawn, the TCR shall be sent back to the court. Yes, next.
Please.
Serial number 4.
2 weeks time.
A week's time is granted to do the needful.
Serial number 5.
Interim order shall stand granted, dismissed without further reference to the court. Interim order earlier granted is extended. Yes, next.
Serial number 5.
So before yesterday matter, Your Lordship, that directed to file the translated copy of the decree, Your Lordship, that time.
Take that.
Good. So page number 8, Your Lordship, that. The suit filed by the plaintiff is hereby decreed. The plaintiffs are entitled 120 SCR in Schedule B property, 114 share in Schedule C property, 15/42 share in Schedule D property. They have right over with possession, Your Honor.
Where is that order?
Your Honor,
Please read. Please read that operative portion.
the plaintiff are entitled 1/28 of their share in Schedule B property, 1/14 share in Schedule C property, and 15/42 share in Schedule D property. Have right over with the possession of their share in the suit schedule property.
Next.
Plaintiffs are entitled to receive rent to the suit schedule property from the date of filing of the suit till possession. The fourth defendant is also entitled 1/5 share in the suit schedule property 1 and 2. Defendant number 28 to 38 are being kept in civil imprisonment for a period of 3 months.
Now please come to the impugned order. What is the sound in the floor? Yes. Where is the order?
So order is the page number, Your Lordship, that 129.
Yes.
That relevant portion is 143, para 19. In the backdrop of the said
For
argument.
the plaintiff number,
So where the plaintiff, Your Lordship, that?
plaintiff number,
Plaintiff number. Asif Khan, where the LRs, Your Lordship, that Altaf Ali Khan. So many LRs. So originally 1 to 6 are the plaintiffs, Your Lordship. That these are the 1 to 30. Now 1 to 63 are the LRs. In fact, all LRs are represented by through GPA holder, Your Lordship, that don't know who is the.
Who are the JDRs?
Your
JDRs are the tenants.
JDRs are tenants, Your Lordship, that.
No, you filed against the JDRs or against the tenants? The court says you filed against.
Defendant 29 to 32 are the tenants. They are also party in that suit. They have also suffered that decree, Your Lordship, that.
Notice to respondent. Yes. Next.
Your Lordship, that
Notice
notice.
to the respondent. Notice. Petition is permitted to take out hand summons from the council and file a memo with the text. Hand summons.
Answer. Seal number 6, KL Park.
I'm permitted to withdraw the petition because I had challenged the issuance of warrant in the consumers forum, which has expired on 20th.
Yeah.
Which was returnable on 20th of January. Now again fresh warrant is issued, so I will liberty to file fresh petition.
The memo is filed seeking to withdraw the petition. It is stated that the petitioner challenged the order dated 18/11/2025, passed in EAN 226 of 2024 by the District Consumer Disputes Forum. Now the fresh NBW is issued and hence they want to withdraw this petition with the liberty. Accordingly, dismissed as withdrawn.
Hearing on आइए. Seal number 7. Surabhi Ravindra Kulkarni.
Appear for the appellant, my lords. Beneficiaries appeal. Challenging enhancement, my lords. There is 1 day delay. There was notice issued. The claimant is served, my lords, and represented.
Usual
Delay may
order.
be condoned. my lords.
Usual order.
Please.
50%.
Obliged.
Yes, sir.
Number 8.
And
Lakshmikant
2024 is filed to condone the delay of 31 days. Condone. What is this matter about?
Case of death.
Claimants appealing.
It's a case of death or injury.
Death. Your
Death.
Lordship. Case of death.
Was it all? Yes.
Yes, Your Lordship. Your Lordship, the accident occurred in the year 2020, Your Lordship.
Use the mic, be little louder.
The accident happened in 2020, Your Lordships.
2020.
Yes, Your
How
Lordship.
much the court has considered the
Your
income?
Lordship, the court has considered income at 13,250, Your Lordship.
13,000?
13,250, Your Lordship. 750, 13,750, Your Lordships. But he is owning a land of 10 acres as per the judgment, Your Lordship. So per acre, 3,000 may be taken, Your Lordships.
Per acre?
3,000, Your Lordships.
Which judgment says so?
Your Lordship, the bench has held, Your Lordship.
My lords, division bench of this honorable court has taken the income at 3,000 per acre, my lords, for the supervisory charges.
Supervisory one.
Yes.
Even if the petitioner is not there, the family will get the income.
But they will lose the supervision charges, my lords. Hence, more than notional
Admit
income may
post
be
of final
taken.
hearing. Call for the TCR. Take a chance.
TCR. Seal number 9. Anantar Latur. Vajjabadi.
137 days delay. And delay may be condoned.
Of 137 days, condoned on condition. Matter is.
And connect with the company appeal, my lord. Connect with, along with one MFA number 100377.
So and so, refer to the Lok Adalat.
No.
No, liability is question, my lord.
We have challenged the liability.
Something is referring to Lok Adalat.
Yes.
Maybe. Please.
Please.
Yes, sir.
No, that matter is listed for
But
referring
they
to
are
local.
challenging the
We have
liability.
They're challenging the right, but then it can't be. Both of them have to be heard, list along with so and so, not Lok Adalat.
Please.
Admit final hearing TCR. Yes.
Seal number 10.
It
is on behalf of,
Kalipati?
there is some
Address
339 days delay in this supplement. Delay may be condoned.
Next matter.
Next one, 10. Serial number 10. On behalf of
357 days condoned on condition. Same order, usual order. Admit fine hearing TCR.
Number 11.
in this case, there is the
This also 339 days condoned, same order.
list along with the MFM
Take
1004.
that. List along with so
Numbers.
and so.
Please.
List 12.
Number 12. Geeta came. Geeta came.
I appear for the petitioner in this case. I appear for the petitioner in this case, Your Lordship. Delay of 22 days in filing.
22 days. Condoned. Admit final hearing TCR. 13.
Seal number 13.
In this case also, I appear for the petitioner. R2 notice is not ordered, Your Lordship.
Notice, R1 notice
R1 is
dispensed with.
dispensed. R1 dispensed, but R2 notice is not ordered. On the same day it is ordered, but it is not mentioned.
R2 is
I
who?
have paid the PF. ICICI Insurance Company, Your Lordship.
Who is R2? Which is the insurance company?
ICICI. Lombard.
General Insurance Company.
Who appears? ICICI Lombard.
ICICI.
So and so is directed to take notice, then counsel the petition, to serve the copy of the petition on the council.
Please.
I number 1 of 2024 to condone the delay of 216 days. Condone on condition.
Yes.
No, it's not.
Much obliged.
216, condone on condition. Yes, for
Delay of 216 days, Your Lordship. Much obliged.
Yes.
Seal number 14.
My lord, appealing for the appellant, my lord, owner's appeal, I have deposited the amount in interim order also, you were also granted by this honorable court. My lord.
Condone on the condition
No.
that, no, if
Owner
he
appeal.
succeeds in the appeal, for the delayed period, he has to pay the interest.
Yes.
Yes, interest, madam, but that is recently Supreme Court has said that the inordinate delay cannot be condoned. Recently, Supreme Court also have held that inordinate delay, exorbitant delay, that cannot be condoned. And similar 2 cases were been dismissed on the ground of delay only. So I am filing the objection may be considered this.
For objections, list after 3 weeks.
2 weeks.
On IA. Yes.
Seal number 15. Surabhi Kulkarni. Prashant S. Hasmane.
Appear for
both matters, my lords, pertain to transfer. So yesterday, my lords, I had given the transfer guidelines, my lords, had passed on.
Not passed on. When it was passed on,
Yes, yesterday, my lords.
it's there in the list. I don't think so.
Prepared in both the cases. This is, my lords, the transfer guidelines.
Sir, circular dated 29/4/2015.
Lords, this one is same, my lords.
29/4. I think this is here. It is here.
Please,
Let's see.
please. Lords, I have also produced, my lords, the translated copies. They, my lords, this is dated, my lords, 29/4/2015. Till then, my lords.
copy.
This circular number 1565. Page number 10, my lords.
Yes.
Yes, my lords. Till then, my lords, we all the 4 corporations, that is KSRTC, NWKSRTC, KK, and BMTC. My lords, all, my lords, same transfer guidelines, my lords. There, my lords, kindly see. Transfer, my lords, one is on request of the employee. Then, my lords, transfer if in cases where, my lords, the employee is involved in a criminal case or on administrative grounds, or, my lords, after a revocation of a suspension order pending inquiry. My lords, these are, my lords, as far as, my lords, his request transfers are concerned, my lords, detailed, my lords.
Let's see. Where
Please,
are they?
please. My lords, it starts from, my lords, page 11.
Yes.
There, my lords, accordingly, the guidelines framed for the division, interdivision, intercorporation transfers of officers of staff in KSRTC corporation and sister institutions are as follows.
Transfer of divisional, interdivisional officers grade 3, supervisory staff.
And grade 4 staff. Now, these petitioners, my lords,
Non-supervisory and grade 4
grade 4 staff.
And to issue transfer orders of the obtaining October from the competent authority.
Here, my lords, in this case, they are grade 4. Please. Minimum and maximum transfer paid for staff officers seeking transfer. This is on. This is for when the employee seeks for, he files an application for transfer. These are, my lords, the guidelines. Then, my lords, for that there is inter-division transfer, between the divisions transfer. Then, my lords, the schedule of the transfer, and my lords, may kindly see page 12 at the bottom, my lords.
As far as 1 is concerned,
please,
that will not apply. To
that will not apply. That will not.
So then we come to 2.
2, my lords. 2, my lords, is the inter-department transfer.
Schedule.
Please, my lords. This is also, my lords, for request transfers. The date of submission of transfer application.
This also applies to request.
Request transfer. Then, my lords, 3.
This is not a request.
Yes. This is not a request transfer. This is on purely on administrative grounds.
Transfer schedule also will not apply.
Then, my lords, transfer guidelines number 3 at the bottom, page 12.
Page number?
Page 12, my lords. Head number 3.
Transfer
guidelines. Here, my lords, for transfer, seniority of the period of service of the employee officer in the present workplace, division, corporation shall be considered irrespective of date of application of transfer. If there is more than one officer employee with equal service, their seniority shall be considered. This again, my lord, on an application. What happens, my lords? Then second, transfer shall be made only as per the availability of the vacant post. The competent transfer authority shall mandatorily display the number
all this for an application.
Yes.
When an application is filed for transfer, what are the guidelines to be followed by you? Is what it is.
Then
where does it apply?
Lords, as far as administrative transfers are concerned, lords, page 14, serial number 8. Page 14, serial number 8. Administrative
guidelines shall not be applicable in cases where there is 2 years remaining before retirement.
That also not applicable. Next, my lords, 8. Administrative transfer for suspension, reappointment, facing criminal procedure, Lokayukta, election commission, etc. shall not be subject to these transfer guidelines. So, my lords, transfer guidelines in respect of, my lords, where they seek for particular transfer, my lords, certain. As far as other matters of transfer, that is administrative, or if he is involved in a criminal case, or transfer after revoking suspension order, lords, we lords take up as per the exigencies of the corporation, and these transfers.
Better put it in this way: as per the whims and fancies of the respondent. Lords, you are an authority, you are a statutory authority.
Please.
It can't be left to the wind like as per your convenience. No, you should be governed by certain rules.
My lords, as far as transfer, my lords, rules are concerned, this is the only circular, my lords.
Then you don't have anything on place. You just do whatever you want to do. It is not permissible.
Lords, as far as these transfers are concerned, my lords, these two petitions, my lord, transfer is on administrative grounds, because the fact that
what are the administrative grounds in the order?
In the order, my lords, order doesn't.
It has to say,
order is not, my lords.
You can't give a vague order saying that administrative, because that is giving you unbridled power.
Lords,
whenever somebody is not, you are not happy with somebody, or any of your officer is not happy, you will do it. That's not right. There is a transparency that is expected.
My lords, in these cases, my lords, the first petitioner was working at a particular place, my lords, for more than 10 years, 12, 13.
Been stated in your transfer order.
In fact, my lords, general orders of transfer are passed.
We can't expect the statutory authority to behave in such a manner. Either you should have rules in place. You say what are the exigencies, where are it? You have to deal with it, because you are dealing with lives of so many employees who are the class 4. How can you simply just say administrative reasons? In several other cases also, there can't be a vague term like administrative. What is that? It should contain.
My lords, the order, my lords, doesn't give the reasons, my lords, but
we have to set aside.
My lords, may I, my lords, make one request? My lords, as far as, my lords, these petitioners are concerned, my lords, may kindly see that one petitioner is,
You have.
they have to,
your
my lords,
own-
come up with some nullifieds or against me.
You have these guidelines on request. Why can't you have guidelines for this also? Are you not supposed to have?
My lords, has,
Governed by something or the other. This is not, you just can't do things at your own.
my lords, my lords, I do, my lords, go down to what my lord says. But as far as, my lords, the case of the petitioners are concerned, my lords, as far as, my lords, the transfer guidelines, my lords, my lords, I will not, my lords, but as far as, my lords, the case of the petitioners are concerned, my lords, kindly see, they have been working at one particular place, my lords, for 15, 16 years. And we have, my lords,
It is a one.
and in the first
no,
case,
no, it is the only one case that where a particular person is working in that place for so many years. Because you do not have any transfer guidelines, and they have been, because class 4, they're working for.
my lords, as far as, my lords, the,
Even.
yes.
Even assuming that, let us say that you don't have transfer guidelines. At least your order should say, what is the reason? Because he is working in that guy, because this is how it is not in the interest of, he is not doing work, or something should be there.
But the order, my lords, doesn't speak in so many words.
It has to go, every order of an authority should be a speaking order.
My
What
lords,
about the next writ petition?
but
In both the cases, same thing.
in next case, here, my lords, what has happened in the first case, he has already joined to the place where he has been transferred in the month of May 2025. He has been working there.
He has.
Having, my lords, he himself accepted the order.
That is always subject to, he is before this court, before joining, like what is, because after what a class 4 employee can do against the corporation.
Lord, he has to, my lords, come up with one
He
specific.
has come before the court, he has questioned
Yes.
it. It is for the corporation to say that our action is, that is, we're deriving some source or to something and pass this on.
But source, my lords,
No source.
no, the grounds, my lords, which my lords are, my lords, we are trying to find, my lords, which is not there. My request is this, my lords, if they have to, my lords, in the writ petition, allege some nullifieds against me, or my lords, come up with specific cases where this transfer is bad. Now, as far as, my lords, rules are concerned, my lords, I am authorized to, my lord, transfer. Now, my lords may say that,
That's what
my lords, as far as on the my lords, garb of the administrative exigencies, my lords,
That also, they should contain
the order has to be a speaking order, my lords. In this case, it is not. But, my lords,
Then I also pass orders corporation, where how many employees are there with the
my lords,
corporation?
there are
And
lakhs together employees.
you should have a transfer guidelines. You can't work like this on your whims and fancies and just say administrative one reason. Please come.
One submission, my lords. To assist your lordships, my lords, the guidelines relied by my learned senior friend, my lords. It specifically, my lord, says in second page, this even, my lord, the guidelines relied by the corporation is not applicable to class 4 employees. That has not been read, my lord, by the learned senior friend. The second page, my lords, which starts with accordingly.
Page number.
Page number second, my lords. 2. Translated version.
Page 11.
Translated version guidelines. Page number 2. Accordingly, the guidelines framed for the division, interdivisional, intercorporation transfers of the KSRTC corporation and sister institution, excluding grade 3 and grade 4 staff. These guidelines are as follows. So even these guidelines are not applicable to class 4 employees.
Please come.
I have already filed one memo, my lord, because I have filed one memo on 12/12/2025.
You are appearing in which case?
15.1 connected matter.
Now first let me pass orders in 15, then we'll come to 15.1. The present writ petition is filed, taking the following prayer. It's a case of the writ petitioner that he was appointed as driver cum conductor in Northwest Road Transport Corporation, referred to as NWKRTC, by order dated 30/5/2006 on temporary basis. Thereafter, the services of the petitioners are absorbed and regularized in the corporation by order dated 12/10/2012 for having satisfactorily completed 2 years of probationary period. He is presently working as driver cum conductor in the Athani Depot, Chikodi division since more than 10 years without any blemish in his service. It is stated that the petitioner had received many awards from the respondent number 3 for the satisfactory service rendered in the corporation. It is stated that all of a sudden, the order impugned is passed, whereby he was transferred on 30/11/2024 by order dated 30/11/2024. He was transferred from Chikodi division to Belgavi Khanapur division on administrative grounds, along with other 43 employees who are transferred on request. And in that petition is the only one who is transferred without a request. Pursuant to the transfer order dated 30/11/2024, the respondent number 4 has passed a movement order on 2/1/2025, directing respondent number 5 to relieve the petitioner from services from Chikodi division. It is stated that employees of the respondent corporation are governed by the Karnataka State Road Transport Corporation within brackets cadre and recruitment regulation 1982. And as per the said regulation, the employees holding division-wise posts will be considered for promotion under the regulations. And in respect of promotional vacancies in the division-wise posts, in their respective division only. In respect of the employees who are transferred from one division to another on administrative grounds, the entire service rendered by them in the division from which they are transferred shall count for seniority in the division for which they are transferred. Such transfer shall be resorted to sparingly. The employees who are transferred to another division on request shall take a seniority in the post held by them on such transfer from the date on which they report in the division to which they are transferred. It is submitted that the petitioner, the respondents without any basis has transferred the petitioner, and having no other go, the petitioner has come before this court filing the present writ petition. When this writ petition a coordinate bench of this court on 31/2025 had granted the interim order as prayed for. That interim order is continued from time to time. The respondent have filed their objections. You filed objections or just a memo?
Objections are filed, my lord.
No, objections are filed on 3/12/2025.
The respondents have filed their objections. In the objection, in the statement of objection, it is stated that
We have denied my lord's his averments, and we have taken a specific stand that since he has already joined to the place where he is transferred, lord's his petition becomes infructuous.
it is stated that the petitioner had joined the Khanapur division and currently working in Khanapur. Therefore, the writ petition has become infructuous. It is stated that objection can't be so vague like the impugned order.
My lord, so we have mentioned, my lord, in para 8 that it is on the administrative grounds.
Petition at paragraph it is stated that the transfer is made on administrative grounds, and that is in consonance with the regulation of the respondent corporation. It is stated that the respondent corporation has authority to effect the transfer on administrative grounds. With only these grounds, the objections are filed. When the matter came up on the last occasion, when this court has posed a specific query to onto the land council for the respondent, what are basing on what are the circular or guidelines that are in place which are governing the transfer of the employees. The learned council has, by way of a memo, has placed before this court the circular number 1565 dated 29/4/2015. It is submitted that on administrative reasons, the respondents have the power to transfer, and as such, they have transferred the petitioner. Next, having heard the counsels on either side, there is the material on record. The respondent is the corporation. Admittedly, the petitioner is a class 4 employee.
Class 4.
Class 4 employee working in the corporation in Chikodi division from the last 10 years.
Yes.
10 years?
Let me say, my lords, he is there from
Appointed
2012.
Huh?
2012.
12.
2012.
That is,
13.
order is in 25. So
25.
almost 13 years.
13 years. 13.
He was working in the corporation from the last 13 years. So till now, there was no transfer, and it is not even the case with the respondent corporation that usually there are general transfers of the class 4 employees. The order impugned, that is transferring the petitioner, say, where is that order?
Annexure A, my lords.
30/11/2024.
Page number?
14.
14.
What it says?
But it only says that, my lords, the petitioner has been transferred
As
on.
per the order impugned dated 30/11/2024, along with 43 employees who has sought for transfer on request, the petitioner is transferred. In that list, petitioner is the only person who has not made any request for transfer. If it is even assuming that there is a necessity, there is a administrative necessity reason behind this transfer, the transfer order should contain, and petitioner cannot be singled out. Except the petitioner, no other employee is transferred on administrative grounds. When an authority is transferring an employee, there should be some circulars, rules in place so that there would be transparency in the manner in which the corporation conducts the affairs. Without there being any circular, if these kind of transfers are upheld, it would not be in the interest of the employees, and there is no fair play in the same. The circular which the land counsel for the respondent is relying on, it applies to the request transfers. And the impugned order doesn't even contain any reasons why he is transferred. What are the administrative reasons, exigencies? The submission of the learned standing counsel, learned counsel for the respondent, that as the petitioner has already joined at Belgavi division, nothing remains to be considered in this petition, and he cannot question the said order, has also no legs to stand.
411 order may kindly be noted. 411 order passed by this honorable court. A subsequent joining my lord to the transfer post, this honorable court has held that it is subject to the result of the repetition.
On 411, on 4/11/2025, a coordinate bench of this court has passed an order that, in the light of the fact that the petitioner has joined the transferred post and working since then, it would remain subject to the result of the petition. Petitioner, being the employee of the respondent corporation, when an order is passed, he has no other option but to join the transferred place. That would not dissentate the petitioner from pursuing this writ petition in the considered opinion of this court. the respondent corporation, the impugned order passed by the respondent corporation is arbitrary without any basis, is not a speaking order, and the same is liable to be set aside as far as you are at serial number
15 minutes.
as far as the petitioner is concerned, who is at serial number
15.
who is at serial number 15. Accordingly, this court is passing the following order. The writ petition is disposed of, setting aside the transfer order dated so and so. As far as the petition is concerned, who is standing at serial number 15. Number 2, the respondent corporation shall formulate the guidelines, even in case of the class 4 employees also, for the transfers, and whenever on administrative grounds, if they have to transfer, the transfer order shall contain the reasons for such order accordingly disposed of.
Both annexure A and B.
One submission, my lords. Since till such time, my lords, where these transfer guidelines are, my lords, framed, my lords, court may observe that if the transfer orders are, my lords, supplied with reasons.
That's what I also said that.
Because in this vacuum, my lords, still such, because it applies to all the 4 corporations.
Till such circulars or transfer guidelines are framed, whenever a transfer is made on administrative grounds, the reasons for the said transfer, the transfer order should be necessarily be a speaking order.
Please.
My lords, both annexure A and B, my lords.
B is what?
B is, my lords, subsequent
Once it goes, it's a consequential order.
consequential order. It needs to be set aside. In my prayer, I have shown.
So next also, in view of the as set aside, consequently, the order dated so and so at so and so is set aside.
Oblan.
Yes, 15.1.
No, rest of the things are same. Only one distinction is, my lord, it is a single transfer order at page number 14.
Let's see that.
Here, my
Annexure
lords,
C, page number 14. In addition to that, my lord,
Let me look at it first.
my lord, it is in Kannada. He has been transferred from Bagalkot to Uttar Kannada, Bhatkal, that is Sirsi division. Sirsi division. And my lord, one more interesting point is, my lord, there are several employees transferred from Bagalkot to Uttar Kannada division. And I have filed memo, my lord, on 11/12/25. The corporation.
What is the date?
What is date of memo dated, my lord, 11/12/2025. There is one document enclosed along with the memo, my lord. In the memo, my lord, I have stated.
Oh, that transfer order is cancelled.
Cancelled.
Why you cancelled?
Though it was for administrative reason. For
there, my lords, what has happened in Sirsi division, my lords, we had hired, my lords, through a labor contractor, my lords, certain employees were hired. They, my lords, their period, my lords, was not extended. The contract period was not extended. There was suddenly, my lords, a very sharp decline of the number of employees, my lords, to run the depot. For that exigency, my lords, several transfers, not only this, there are other, my lords, several orders were passed transferring them.
Then?
Please, my lord.
Why not the petitioner?
My lords, petitioner, my lords, has been working in Bagalkot division for the last 18 years. And there, my lords, along with my state...
All other employees are not...
No. Apart from that, my lords, one, the number of years that he has been working. The second, my lords, that during that 18 years, my lords, he has, my lords, accumulated sufficient default cases. He has found his comfort zone in Bagalkot. Now, my lords, to take him out there and, my lords, put him in a new place, my lords, his old habits, my lords, will die. My lords, he has found his comfort zone in the old. In fact, in my vacating application, my lords, this is what I have mentioned, and I have also produced the default cases that he is suffering. Though, my lords, in those default cases, several...
What did you do for that?
Punishments were imposed. He has undergone those punishments, but has continued to, my lords, carry on his old habits.
Please come. The present petition is filed. Taking the following prayer. In this case, you have not joined.
I have not joined, my lord. There was an interim order. It was not obeyed and contempt is filed.
The petitioner has joined as a any conducted in year 2006. Thereafter, he has been transferred to Bagalkot division by order dated 21/5. 2007. He has been working in Bakalkot Depot. He's a class 4 employee. On one occasion, he has returned the iPhone of the passenger who was left in the bus in which he was discharging the duty. On another occasion, the person has left 60,000 cash in the bus, which was kept in small bag that was also returned to the concerned passengers in front of the departmental officials. It is stated that he has been working in the Bagalkot division without any remark or not even a single black mark in his career. The petitioner was surprised to the surprise of the petitioner. The impugned order is passed by the respondent on 13/9/2025. It is stated that as per the same, he has been transferred from Bagalkot to Patkal Depot of Sirsi division. The petitioner is deemed to have been relieved on the same day. It is stated that there are school-going children, and apart from that, their own circulars and settlements prohibit the transfer from different divisions unless there is such an exigency. It is stated that he has not been served with any of the orders mentioned in the reference made in the order dated 13/9/2025. Land Council, it is submitted that Land Council for the petitioner submits that there are no such transfer guidelines in place in the respondents have passed an order without even stating what was the reason for the transfers. And the transfer, the same as bereft of any reasons. It's not a speaking order. It is Land Council submits that during from the same division to Sirsi.
Please,
16
division.
employees are transferred.
Yes, 13.
13 employees are transferred, and their transfer order is cancelled by the respondent, which shows that the respondents are exercising the power arbitrarily and discriminatively. It is submitted that the impugned order needs to be set aside. Land Council, the MMO is filed, objections are filed by the respondents.
Vacating application. my lord.
Objection is not filed, my lord. Vacating stay
Filed vacating application wherein, my lord.
Is filed in that. Where did you say so about his conduct?
Lords, para number 3, my lords. It is most humbly submitted. The petitioner was appointed as a trainee, so and
Stated that petitioner has been working in the Bagalkot division since 18 years. During this period, he was involved in 9 cases of absenteeism, 12 cases of pilferage. And the amendment made in the petition that he has been working in the Bagalkot division without any remark and not even a single black mark in his career is false. Even though punishment was imposed upon the petitioner, he has failed to correct himself and has continued to commit default cases. It is stated that to address the issue of shortage of staff in Sirsi division and with the intention to smoothen the functioning of public service for the purpose of ensuring better service delivery to the public at large and for the purpose of optimal utilization of employee skills, experience, the petition has been transferred to Sirsi division. It is on administrative grounds, not by way of punishment, which the petition is trying to portray. Further, it is stated that as he's been working for Sirsi from the last 18 years, it justifies the transfer of the petitioner. The order sheet. On 25/9/2025, the coordinate bench of this court had had granted interim order and also permitted the petitioner to continue at the same location that he was serving prior to the issuance of the order. In the light of the same, the petitioner is continuing.
No, I have not been continued, my lord. I have filed contempt. After,
Allowing you.
they have not allowed. I made a representation.
Submitted that in spite of an order before by this court. Respondent have not permitted the petitioner to serve as per the impugned order, as per the interim order, which has been continued from time to time. From time to time. Next, having got the counsels on either side, there is a material on record. The petitioner was transferred, and the vacate petition filed by the respondent says that the transfer is not a punishment, though it is stated that petitioner was involved in some pilferage and other issues, but according to them, the transfer is not as a punishment, but as a required.
That was, my lord, submitted to counter his statement in the writ petition. Please.
On administrative reasons, as there is a requirement of the staff in Sirsi division. If that is a submission of the learned, if that is the case of the corporation, the order impugned before this court needs to be set aside on the ground that when on that exigencies, when other 13 people are transferred to Sirsi, the court, they have later withdrawn the same, and has permitted all of them to work in the same place as they were working earlier. The order the order impugned before this court does not contain any reasons why they have done. It is the administrative reasons. Then what you do is remaining whatever in the earlier order on facts other than the fact, remaining same should be copied in this. Finally, accordingly, the order dated so and so is set aside. Then the same whatever 2-3 guide given, that also should continue in this.
May I request one more thing, my lord? He is in hardship. Neither he is given employment nor any salary for all these months.
No, you have all the more reason. They will do it. Yes. Yes.
Number 16, GN Raichur.
Right, application for withdrawal of amount.
Appears, where is Mr. GN Raichur?
He was there, but I think he in the other court, not.
I number 2 of 2025 is filed for the withdrawal of the amount. Accordingly, I number 2 is allowed. Yes, next.
Seal number 17, Nasab Shalgar.
These matters have become infructuous, and my lord, alternate remedy is under section 83(9) before WAF tribunal. Last week matter was listed.
You sought for time
Yes,
on the last occasion.
my lords, in the listed matters, my lord, except the serial number 17.2, all the matters pertains to different work institutions, and my lords, only 17.2 was pertains to another work institutions. But the issue is in lord is same. That, my lords, there is an alternate remedy. I have to go to the tribunal, but this court has exercised its jurisdiction, my lords, and had granted a stay in all the 3 matters. Lords, the order that is challenged before this honorable court, my lord, is arbitrary, and my lords, it is passed without giving notice to the petitioners. My lords, the jurisdiction can be exercised by this honorable court.
Let's come to the
Yes.
come to the order.
Yes.
What is the order?
My lords, kindly take the writ petition number 107338.
No, let's see. Let's start from 104 to 68.
4 to 68, please. That is the first writ petition, my lords, filed by the petitioners.
Quashing the impugned public notice.
Yes.
By the respondent number 4. What is the public notice?
My lords,
Public notice for
public
what?
notice. Lords, there was a committee that is formed in the year 2022. It came to end on, my lords, 5/4/2022. After that, my lord, there is an extension granted to the committee with the specific direction that they have to form a regular managing committee. That extension, my lord, period is expired on 4/7/2025. Before, my lord's expiry, they called for the general body meeting by issuing a public notice. That public notice, my lords, is at page
No, according to you, that is expired in December, that even that extension of extended time also.
Extended period also expired. Before that expiry, my lord, they just called for a general body meeting by issuing a public notice.
Order. You have an
We have
interim order.
interim orders. The interim order is, my lord, that the committee should not have any further, my lords, meetings until this is order, my lords. After that, my lords, Rule 54 will operate. The Rule 54 of the work rule.
No, no, before going to Rule 54, now by virtue of this order.
Please.
This order, after this, that body is no more in existence.
Please, lordships, please. The functus officio.
What do you want to
Yes.
argue on in this petition now?
Yes. Now, my lords, this writ petition is having an interim order, my lords. I did not seek for, my lord, the writ petition will not become infructuous because after that, my lords, I filed another writ petition. That is in the writ petition number 107338.
Just,
This will also be infructuous, my lord.
so I will pass orders on this, then we'll go to the next writ petition.
Yes, please, lordship.
The present writ petition is filed, seeking the following prayer.
On the ground that your term has been
It
expired.
is a case of the petitioner that the respondent number 4 is a Waqf institution. The Karnataka State Board of Work constituted the managing committee of 21 members for the management of the work. Petitioners are the residents of the Alnavar Taluk, Alnavar district, Dharwad, and they are the members of the work. And they have a right to participate in the election of the management of the work institution. The term of the managing committee constituted by the order of the board dated 6/4/2022 came to an end on 5/4/2025.
And same was extended.
The scheme of administration of Anjuman was approved by the respondent number 2 by its order dated 30/11/2024. It is stated that as per Rule 54 of the outgoing committee, prior to 3 months to the expiry of the term, shall complete the entire process of constitution of succeeding committee. If for any reasons succeeding committee is not constituted or appointed, the management and supervision of such work institution shall automatically vest with district work officer in terms of Rule 54(6), the outgoing committee shall cease to have any power or authority for the management of the work institution. It is a grievance of the petitioner that the respondent number 4 has issued a public notice calling for the general body meeting to be scheduled on 3/7/2025. That notice is impugned in this writ petition. Land counsel for the petitioner submits that the term of the committee was extended till
4/7.
Till?
Till 4/7.
4/7/2025. 4/7/2025. This court has already granted an interim order staying the operation and further proceedings arising out of the public notice dated 25/6/2025 as 25.
No, no, sir.
On the ground that, my lord, term has
second.
already been expired.
No, second.
Yes.
You said it is 11 or 12.
No, they say that, my lord, it has been expired. Suppressing the pact of, my lord, it has extended up to 4/7.
In that, my lords.
By the time the writ petition is filed, it is already extended.
Yes, not, my lord, by virtue of the order passed by the board, it was extended to 4/7. That order was not before the
No. That
brought to the
extension
notice.
is before filing the writ petition or after filing the writ petition?
Before, my lord.
Before
That was
filing the
not
writ
brought to the
petition.
notice of the court.
For your submission.
That was not brought to the notice.
And
Lords, for that, my lords, I have submit one submission, my lord,
Then
where the rule, my lord,
interim stay as prayed for was granted. Then counsel appearing for which respondent?
My lord, I am for the first respondent. Sec-
23.
Is appearing for what board?
23.
Second respondent?
Second respondent board. My lord.
No.
Second and
Fourth
third.
respondent is Waqf.
Yes, my lord. Second respondent board. My lord, I am
You appear for the state board of Waqf.
State board of.
Then counsel
And
appearing
also,
for the
my lord,
second
district office.
submits that. By the time the writ petition is filed, already the period of the board is extended till 4/7/2025.
And general body was, my lord, it is held, my lord, they have issued a notice for calling for the meeting to elect the, my lord, committee on 3/7.
It is submitted.
That is, my lord, before.
Yes.
Submitted that suppressing the said fact, the present writ petition is filed. Learned counsel for the respondent.
My lords.
Petitioner had denied the same. Next paragraph. Having heard the counsels on either side.
My lords, in this, my lords, I have produced the scheme of administration. The violation, what I have done, my lord, is chapter 6.
Reserve your energy for the next writ petition.
Lords, I have the energy for the whole, my lords, whole petitions.
You leave it there. As the petitioner had sought for the quashing of the public notice dated 25/6/2025. Already an interim order is granted. Whatever the relief that is the petitioner is seeking is already worked out and nothing remains for adjudication in this writ petition. Accordingly, dismissed as instructions. Now you argue the second writ petition.
Lords,
17.1.
17.1.
please.
What is this writ petition about?
17.1, my lords, I have challenged the order dated 25/9/2025. Annexure, my lords,
25/9.
annexure A, page number 18.
Page number?
18.
Please read.
My lords, this is an order passed by the respondent number 1, my lords, who is the Karnataka State Board of Waqf, constituting a managing,
Let's read it.
please. From the extension of the term of the managing committee for the management of Anjuman-e-Islam, Al-Nawar, District Dharwad. Operating portion order number so and so dated 25/9/2025 in exercise of the powers conferred under section 32(2)(g) of the Umeed Act 1995, Unified Work Management Empowerment Efficiency and Development Act 1995. The Karnataka State Board of Waqf hereby approved and constituted the managing committee comprised of existing 21 members, managing committee for the management of Anjuman-e-Islam, Al-Nawar, District Dharwad for the period of 6
Order passed.
on 25/9/2025.
25?
9.
2025.
25.
Now this is extended to 6 months.
6 months.
So when it will complete?
In the month of March, Jan.
So what is wrong with this order?
Lords, before passing of this order, my lord, there is another order passed by the very same respondent, my lords, on 19/9/2025. That order is at page 39, your lordships, annexure G.
39.
39.
Yes.
Yes. Lords, I may permit to read the order. Appointment of caretaker for the management of Anjuman-e-Islam, Al-Nawar, District Dharwad. In this, my lord, paragraph number 4. Further, the Honorable High Court order number, writ petition number 1053331 of 2025, dated 1/8/2025, and the Honorable Chairman, Karnataka State Board of Waqf, Bengaluru wide, note dated 16/7/2025, has directed to appoint Shri.
Let us see this order, WP number 10533.
Please, your lordships. It is at page, my lord, 35.
Yes.
Yes. Lords, this writ petition was filed, my lord, seeking direction to.
File the writ petition.
We have filed the writ petitions. Lord, seeking directions to the, my lord, the note issued by the chairman to the district work office, to the CEO of the Waqf board. That note is also I have produced, your lordships, at 34, page number 34. Once.
So what happened to this order?
Yes. After the issuance of the note, my lord, we filed a writ, and the writ, my lord, the matter is disposed of, directing the CEO to appoint a caretaker. That is the order passed, my lord. Pursuant to that, my lord, the 19/9/2025 order is passed. Caretaker is appointed. When caretaker is already appointed, my lords, after 10 days, after 7 days, my lord, they passed another order extending the period of the managing committee, which has become functus officio on 4/7/2025. That is after 2 months and 10 days, my lords. Since, my lord,
What does the provision say?
my lords,
What does the provision say?
provisions 54. Rule 54, my lords, will operate.
Yes.
Appointment of mutawalis or managing committees.
Yes.
Lords, Rule 4, my lords, states that if, Rule 4, if in the event of existing managing committee fails to initiate and complete the process for constitution of succeeding committee within the time prescribed under sub rule 2 of Rule 52 of the Rule 52, the district work officer shall initiate such process within 2 months prior to the expiry of the term of the existing committee and complete the process prior to the expiry of the term of the existing committee. Rule 5, my lords, if for any reason succeeding committee is not constituted or appointed, the management and supervision of such work institutions shall automatically vest with the concerned district work officer, and the district work officer or any other officer authorized by the board shall carry out the duties and functions as delegated by the Karnataka State Board of Awqaf. He shall take action to get the succeeding committee within a period of 3 months. After that, my lord, 6, such committee shall cease to have any power or authority for management of such work institution, including operation of bank accounts after expiry of the term. My lords, it's clearly stated in Rule 4, my lord, that once, my lord, the committee got expired, the power vested automatically with the, my lords, the district work officer. In this case, my lord, the district work officer has not obtained a charge, my lords. We gave a representation to the chairman and the CEO that the caretaker has to be appointed. My lord, since he has slept over his duties, my lord, we filed a writ petition that is 105331 by 2025. In that, a direction was granted, my lord, to consider the representations and pass in necessary orders. Since, my lord, the CEO has passed an order on 19/9/2025. After the passing of that order, my lord, he passed the extension order to the committee who has become in functus officio. Hence, I am before, my lord, challenging this order.
What do you say?
My lord, so far as the 54(5) is concerned, my lord, it is immediately on the, my lord, the term of constitution, my lord, the term of committee is expired. But it is, my lord, admitted that, my lord, it vested with the work officer, district work officer.
On 19/9/2025, you will
Yes.
pass an order
Yes.
appointing
The caretaker.
caretaker.
Yes.
Then why did you extend the term thereafter?
My lord, in fact,
What is the purpose of appointing a caretaker? And why should
caretaker,
you-
my
why
lord, there is no provision as such, my lord, in the act. My lord, they sought for, my lord, writ was filed by them, seeking a writ of mandamus.
There is no provision, you wouldn't have appointed.
Not have been appointed.
And then
But it
after
is, my lord,
which provision in the act will give you the power
To-
to extend the committee's tenure of a committee after it expired 2 months after 2 months after the expiry?
no, before that itself, my lord, it was extended, my lord, it was recommended by the district work officer before expiry of the term. It is, my lord, recommended by the,
Whatever, no, you have
that
appointed,
subsequently board has passed the order because board meeting could not be taken place.
you have appointed a caretaker. Whatever
Caretaker, my
the
lord,
purpose is caretaker can also take care of what the committee can do.
Yes.
No, it can prepare everything for the further next committee and other
Right.
things. So
Only-
what is the
my lord,
requirement? Unless and until this order dated 19/9/2025 is withdrawn or for some other reason you take any other action.
Right.
Where is the question of extension?
my lord, because, my lord, the caretaker, my lord, could not take, my lord, charge because
Is that?
he could
Where
not
did you
take charge.
He couldn't take charge.
My lord, because, my lord, is, in the meantime, my lord, in view of his official capacity,
Order contains, so where is the extension order?
the extension order, my lord, at page number, annexure
Let's read.
Annexure A, my lord.
Yes.
Page 17.
Yes.
22. Oh, sorry. Page 18. Extension order. Annexure. G.
Next. ಅದಲ್ಲ. ಕೊಡ್ರಿ ಕೊಡ್ತೀನಿ.
1 minute. That is, my lord, the impugned order, my lord, in this writ petition, my lord, in fact. So, annexure A. That is, my lord, 25/9/2025. Annexure A, page number
Yes, I'm looking at it.
18, my lord. Page number 18.
Yes, yes.
That is, my lord,
Say so.
examined in detail from the file, it is noticed that work officer, district work advisory committee, Dharwad, recommended the proposal to extend the term of managing committee of Anjuman Islam, Karnataka, Dharwad
You have not
district
stated,
for
I
a
read
period
that.
of 6 months.
I
That
have
is, my
read
lord,
it. You have not stated anything about this appointment of, why was
it is
the
not,
caretaker
my lord. In fact,
appointed?
it was.
What happened to that order?
It,
Why was the reason for extending?
it was by mistake, my lord. In fact, he could not take charge, my lord. That's why, my lord, this order has been passed. Now, even till to this date, my lord, because he has been.
As rightly argued by him, when once a caretaker is appointed, how the function,
The appointment of, my lord, in fact, caretake question of, my lord,
Why did
only
you-
by the chief officer, my lord, in fact, not by the board. Board constituted, my lord, meeting was constituted subsequently. Board has passed the order for appointment of, my lord, extension,
officer,
my lord, chief executive officer.
so chief executive officer,
But at least, my lord, he was under the impression that, my lord, there is a direction by this
if he
order.
has
That
if
is,
he
my
has
lord.
an impression, that order
Yes.
needs to be set aside. Then only you can do something.
It is not been challenged. In fact, it's
What
not.
he will say, you are the one who appointed.
No, it has not been challenged, my lord, in fact, not even challenged.
Not challenged, you have to go,
Caretaker
you have to
appointment.
withdraw that order.
No, my lord.
That order needs to be withdrawn.
Challenge, my
Without
lord.
withdrawing it,
My lord, it is stated that, my lord, it has been challenged before, my lord,
When is up-
work tribunal.
Before WAF tribunal.
no order is passed as of
No,
now.
no order has been passed. So far as, my lord, this matter is also, my lord, requires to be, my lord, tried by the
We'll
work.
set aside this order.
My lord, it
Then
is
both of them go before the work
work
tribunal and
tribunal. That's
decide
what I am
that.
saying. Work tribunal is having the competence, my lord, to decide.
Last
who
time
is
I
not.
had given a Supreme Court judgment. That was followed by a division bench of this honorable recently.
I'll record that also, please take that. Present writ petition is filed, seeking the following prayer.
My lords, may I,
Caretaker appointment
lords,
challenge, my
kind
lord.
indulgence, my lord. The matter is, my lord, referred to the tribunal, my lords. Nothing will survive, my lord.
No, what I'm saying is, we'll set aside this order. Committee's extension of time.
Please, your lordships.
Appointment of caretaker is questioned by them before the tribunal.
Please, your lordships.
To also go there and contest.
We have filed already an
Filed an
impleading
impleading application
application, my
there.
lord. That impleading application is already allowed, your
Pleading
lordships.
application.
The board endeavor is, my lord,
The scope of this writ petition is
my lord,
only
ultimately,
annexure A.
hello,
Now
please.
I'm going to set aside this order.
Hello.
You have to go necessarily.
Ultimately, the board endeavor is, my lord, that the committee should require to be, my lord, constituted in a general body. That's exactly, my lord, what requires to be done. Now,
My
but
lords,
for the reason that, my lord, they suppress the fact of, my lord, the earlier, the extension and obtain an order of stay. That's why, my lord, it could not be extended. That's exactly, my lord, the situation.
in the serial number 17.3, my lords.
By these litigations,
Lords, one submission, my lords, in that. Lords, he has obtained, my lords, interim stay on the appointment of the caretaker.
That's what
Please.
we will decide that also. Ask him to go there only. Take
Please.
those judgments. We'll ask him also to go there.
yes.
Please.
What my respectful submission is that at least committee, my lord, is required to be constituted, my lord, immediately. But for the reason of, my lord, the interim order obtained by them.
Then in that case,
So, my lord, now otherwise what happened, my lord, it will be
who will appoint the fresh committee?
committee, my lord, is required to be, no, it is required to be, my lord, in general body. General body could not be taken place, but for the reason that there is an order of stay. That's exactly, my lord.
Two issues.
Yes.
One is, you have extended the tenure of the committee. According to you, that committee has to have a general body meeting and appoint.
That is, my lord, it is
that is now,
My-
that extension itself is bad.
My lord's kind
Yes.
permission.
If the committee is not in place,
Yes.
if the committee is not in place, who will appoint who will take the?
My lord, it is, my lord, the district, it is district work officer who can, my lord, either recommend for, my lord, the extension of the existing committee, the term, or for, my lord, appointment of administrator. So now, suppose, my lord, if for any reason, my lord, it could not be done, District work officer is required to, my lord, either for extension of the term of, now your lordship is holding that it could not be done because the term is already been. Now, only other alternative is, my lord, to appoint the administrator and to hold the election, my lord, immediately. Otherwise, my lord, this, my lord,
Direction will pass.
this, my lord,
That's what, my lord. That's what I'm submitting, my lord. Wherein, my lord, the all issues revolving around the appointing of the committee, my lord. Wherein the earlier committee tenures was ended
one
up.
or the other
Now,
pretext, my lord,
now
they are
the board
before
has
this
to take
honorable
a call.
court.
Why,
Please,
in the interest of both
Please.
of you,
Please.
now let that officer take steps for appointment for constituting a new committee.
Our request
It is,
before
my
this
lord.
court is that, my lord, this court may direct the board itself very well before this honorable court. Ultimately, board has to take a call, my lord. Moreover, the district of officer, my lord, he is not operating his duty, my lord. That's what we are before this court.
No, no,
Time
no.
and again, my lord.
District work
One more,
officer, my lord,
one more,
Now I got
hello.
this communication. My lord, board has taken steps to follow for kindly see me.
If at all board take a call, my lord, entire issue will end up, my lord. Nothing survives, my lord.
He has something, you have a copy of it?
Please, please,
Yes,
let him, please.
I'll give.
A copy.
Yes. Returning officer is appointed to
Again, my lord, there was another extension, my lord. This again, my lord, the extension earlier was passed in the 32 DG.
direction to hold election. My lord, every problem will be solved by this.
My lord,
my
this,
lord, it's-
this extension will again, my lord, create a trouble, my lord. My kind submission to this court is that, my lord,
One or the other
if at all
pretext, my
this
lord, they are approaching this honorable court, obtaining an order.
That's why, no, let both of them, you do it
Yes.
independently.
Yes.
You do independently, let them not do, let
Yes,
let
yes.
not,
Yes.
but
Please,
but you
Let
do.
off officer do it.
Yes,
Appointed, any officer appointed by you will do it.
yes,
Let-
my lord, that
let
is
not
exactly, my
disturb.
lord, it's required to be done. Otherwise, my lord, this dispute would continue more forever.
So where is now 17.1 is this, 17.2 is?
That is petition filed by the opponent council, my lords.
It is by me, my lord.
No, 17.2 is also by, 3
No, my
is
lord,
by
no, my
you.
lords. 17.2 is my petition, lords. This pertains to another work institution.
So let's not.
It has to be segregated, my
It has
lords.
to be dealing.
Not dealing, it has to go before, last time.
No, lords, it has to be segregated for a
You
moment.
said it, you have to go before. So
Let us deal with 17.1 and 7.3.
Yes, yes, yes.
I will pass a common order in this.
Yes.
17.3, you have questioned the appointment of caretaker.
No, my lord, I have, my lord, what happened, my lord, during this pendency, my lord, my new WAF Act came into existence. But there was a direction by the central government to the WAF board that, my lord, there was a Umid portal that they have to, my lord, mention it in the, my lord, computer data. Therefore, my lord, what the general order was passed by the WAF board, saying that the term of committee which are expiring on or before, my lord, on 1st of August, that will be continued till 31st January 2026. Therefore, I had approached this honorable court for extension till 31st. Your lordship now are passing order to hold election. My lord, nothing survives in my petition also.
Give that also. The 17.3.
Contempt के साथ एक मेन में तो गए बाद है.
My lords, one submission, my lords. My lords, by virtue of the interim order passed in the matter, my lord, 17.1, we have filed, my lords, contempt. And, my lord, in that, my lords, contempt notice is already issued to the.
Then this is.
You want contempt, now when there's a positive order is passed now.
Indeed.
So you ultimately have to, it has to be taken to a logical end.
Yes.
You want a committee to be constituted, let it
Please.
let it be
Please,
done.
lordships.
Please.
The WP number, common order in WP number 107338 and WP number 108618. WP number 107338 is filed, seeking the following prayer. Then WP number 108. No, first is WP 107338.
Yes.
The following prayer. Then WP number 108618 of 2025 is filed, seeking the following prayer. The case of the petitioner in WP 10733. It is a case of the petitioner that the Karnataka State Board of work constituted a managing committee of 21 members for the management of Anjuman Sham Al Nawar for a period of 3 years by order dated 6/4/2022. And the petitioners are the members of the general body of the said work. The term of the managing committee came to an end on 5/4/2025, and it was extended for the period of 3 months that expired on 4/7/2025. On 36/2025, the district work officer Dharwad wrote to the chief executive officer forwarding the representation of the president of the outgoing managing committee seeking further extension of the committee's period for 11 months. The general body members have submitted a representation dated 14/7/2025 requesting respondent number 1 and also to the chairman Karnataka State Board of Work to safeguard the assets and interests of the work. The chairman of the Karnataka State Board of Work considered the request and issued a note dated 16/7/2025 addressing the chief executive officer of the board to appoint a caretaker for managing the day-to-day affairs of the work, since there is no management. Then the caretaker was appointed by proceedings stated 19/9/2025.
Yes.
Was appointed by proceedings stated 19/9/2025. Now it is the grievance of the petitioner that the respondent work, the state work by order dated 25/9/2025 has extended the period of the outgoing committee. That is read as respondent number. Yes, Mr. Counsel. Read as respondent number.
1, my lord. Work board is 1.
No. Not respondent number 1, 3. The term of the third respondent was extended by order dated 25/9/2025. It is a contention of the learned counsel for the petitioner that when once a caretaker is appointed, the committee whose term is expired on whose term was expired on 31/7 4/7/2025 has become functus officio, and question of extending the same after or extending the same on 25/9/2025 is contrary to the provisions of the Work Act. It is submitted that the state, the first respondent, there is the obligation is on the first respondent to see that a committee is constituted in the interest of the work, and the first respondent is not taking appropriate steps for constitution of the work, and they are passing orders one after the other contrary to their own orders, one order to the other. It is the submission that when the order dated 19/9/2025 is in subsistence, question of passing an order on 25/9/2025 does not arise. Next para. Learned counsel appearing for the first respondent submits that in fact they want to take steps in the interest of the work, and but the third respondent on the petitioner are litigating the matter by coming before this court and going before the work. When a caretaker is appointed, the third respondent has questioned the same before the work tribunal, and the petitioner has come before this court by filing the writ petition. It is submitted that if the steps are taken and the committee is constituted, all the disputes will be resolved. Next, learned counsel appearing for the third respondent submits that the writ petition is not maintainable. The petitioner has an effective alternative remedy under section 1 not?
No, 83.
Under section 83 to go before the tribunal
Court of
Give that. Judgment he is relying on.
First matter, my lord, para 16 of Supreme
He
Court.
relied on the judgment of the apex court in Board of Waqf, West Bengal, versus Anis Fatima Begum and another on 23 November 2010. He relied on paragraph number
16.
16, extracted.
The same is confirmed by a division bench,
It is submitted
considered by
that
division.
even a division bench, where is that?
Next judgment.
It is that relying on the very same judgment, a division bench
Para 9.
of this court in case of Waliala, how do you spell it?
Olialla.
Waliala and Karnataka versus Karnataka State Board of Work, arising out of writ appeal number 100561 of 2024, has held that as there is an alternative remedy, the petitioner, the aggrieved party has to go before the tribunal under section 83. It is submitted that the writ petition has to be dismissed. You represent whom?
No, he doesn't. He's assisting
all of you.
Yes, ma'am.
It is submitted that the petitioner may be relegated to the tribunal. Next paragraph. Having heard the counsel, next, keep it there. Then WP number 108618 is filed by the third respondent in WP number 107338 of 2025. It is a case of the writ petitioner that the respondent, that he has made it, they have made a representation to extend the time of the general body meeting is called on 3/7/2025 to hold the election. And a writ petition is filed before this court, that is WP 104268 of 2025, and obtain an interim order on 2/7/2025, staying the general body meeting. And the petitioner has filed the vacate petition and the same is pending consideration. It is the case that respondent number 1, due to political influence on 23/9/2020, on 19/9/2025, appointed respondent number 3 as caretaker of the petitioner's institution. Then they have filed. What happened to this 10533?
Oh, that is disposed.
Then they are questioning the same. They have filed WP number 10, alternative remedy.
No,
It is withdrawn.
Huh? Withdrawn.
It is not by me. ಯಾವುದು?
One case ಅವ್ರು ನೀವು withdraw ಮಾಡಿದ್ರೆ ಅವರು
10533 that only there was interim order of appointment of caretaker. 10533.
It is stated as forget about that. It
Lords,
is stated that
that matter is disposed of, my lords.
the respondent number 1 by order dated 25/9/2025 extended the period of the committee for a period of 6 months. And it was challenged by filing 107338 of 2025. And on 3/10/2025, stay was granted. It is stated that on 30/10/2025, the state government has passed the transfer order, transferring the respondent number 3 to respondent number 1 office. In the meantime, the respondent number 1 by proceedings dated 30/10/2025 passed an order by extending the term of the managing committee and mutawallis in the state in view of UMEED portal, as there was a direction by the central government for updating Waqf institutions by the managing committee. It is stated that respondent number 3 came to the office of the petitions institution and tried to interfere with the affairs of the managing committee in spite of he being transferred at the instigation of some of the persons. The respondent number 3 has not taken charge. And the petitioner brought to the notice of the respondent number 3 about the order and the committee, that the term of the committee is extended. It is the case that the respondent number 3 is trying to interfere with the affairs of the work, petitioner work. As such, the petition has come before this court, filing the instant writ petition. Next one. Having heard the counsels on either side, the petition on record. As the both writ petitions are pertaining to the same work, and almost the parties are one and the same, these writ petitions are disposed of by way of a common order.
Pending ayes may kindly be allowed, Lordships. Pending aye, impleading application I have filed, my Lords, in this.
Let me complete this. We'll pass an independent order for that. In WP number 107-338 of 2025, the grievance of the petitioner is, once a caretaker is appointed, the first respondent board ought not to have passed an order extending the term of the committee, which was expired 2 months back. And the committee, which was the term which was expired long back, has become functus officio. This court finds force in the argument of the learned counsel of the petitioner. When the chief executive officer has appointed a caretaker to take care of the affairs of the institution, the work, on 19/9/2025, why on 25/9/2025? Why they have extended the term of the committee is not known. The first respondent ought not to have passed such an order. Next one. It is a submission of the learned counsel for the third respondent that the writ petition is not maintainable, and he has relied on certain orders passed by the court. A series of writ petitions are already entertained. Interim orders are passed. After entertaining the writ petitions and after passing an interim order, at this stage, this court is not inclined to go into the aspect of maintainability of the writ petition. The next paragraph. In the interest of the institution, in the interest of the work, there should be the first respondent ought to have taken the necessary steps. Hence, in the interest of the work, which is even as per both the petitioners, it is submitted that all these efforts are made in the interest of the work. In that view of the matter, this court is of the view that the order that is passed by the first respondent extending the term of the board
managing committee.
Committee has to be set aside. Even the appointment of the caretaker also needs to be set aside. Accordingly, the proceedings dated 19/9/2025 and 25/9/2025 are set aside. Number 2, the first respondent shall take necessary steps for constitution of the new committee to the work so and so.
In accordance
to the third respondent.
In accordance with the
Rule 54.
No, it is in accordance scheme of the administration.
Shall take steps for constitution of the committee as per the scheme of
administration
within a period of
3 months.
3 months. 3 months.
Within a period of 3 months from the date of receipt of the copy of the order.
In the meantime,
Since there is no committee, let an administrator
be appointed
for this purpose.
Still,
district work officer administrator may kindly appoint as administrator.
District
work officer. Respond number 2 in the
till the committee is constituted, district work officer is appointed as the first respondent shall appoint the district work officer as a caretaker.
Administrator.
Please.
Accordingly, both the writ petitions are disposed of.
Pending,
Plead, you're saying?
pending IS, my lords, in the.
Pleading IS.
In pleading.
IS. In which case?
17.3.
Huh?
17.3, 108618 for 25.
Whom to be impleaded?
The varies, no, my lords, in his petition, my lords,
Proposal, nothing survives, because now.
in his
all-
petition, my
all
lords, I have,
Contentions are left, they are.
IS may kindly be disposed of.
All IS stands closed.
Please.
Yes, 17.2.
please,
He has alternate remedy, my lord, he has to.
Let's
go.
see what it is.
please, your lordships.
Yes. What I have a question in this?
Thoughts. In this
Annexure E,
petition, my
ma-
lords,
The order bearing number dated passed by respondent number.
Annexure E in page 53.
Interim order is granted in this.
No,
one.
no.
no, my lords,
Interim
no
order.
interim.
My
orders granted.
committee is on 13/3. From last 10, 11 months, we are, my lord, functioning. He has to go there, my lord, as per.
Read the order.
Please. In view of facts mentioned in the preamble and excess of powers conferred under section 32G of WAF Act amended 2013, read with section rule 54 of Karnataka WAF rules, the Karnataka State Board of Health hereby accords approval for constitution of following 11 members, managing committee for management of Noor.
This.
Yes. My lords, this order is passed, my lord, during the subsistence of an earlier existing committee as per annexure C.
Now, in this matter, there is no interim order. Go
Yes.
before the tribunal.
Lords, since,
Question before the tribunal. In the light of the division.
my
bench
lords,
order.
before passing this order, your lordship, they have not asked for the objections, my lord, they have not given.
That procedure, the whole purpose of the Waqf tribunal is that the present writ petition is filed. Seeking the following prayer. Land counsel appearing for which respondent you appear?
My lord, appear for respondents 5 to 13.
5 to 13.
Yes.
Relied on the judgment, same in the earlier matter. Relied on the judgment of the Honorable Apex Court as well as judgment of the division bench of this court and supports that the remedy available to the petitioner is go before the tribunal under
lords.
section 83 of the Waqf Act so and so. Accordingly, the writ petition is disposed of giving liberty. Accordingly, this court is passing the following order. Writ petition is disposed of giving liberty to the petitioner to avail the appropriate remedy before the Waqf tribunal under section 83 of the Act.
I am appearing for respondent number 1 and 2, madam. In this matter, I am appearing for respondent number 1 and 2. Please note
Then
it.
counsel is appearing for respondent number 1 and 2 and 3 to
13.
3 to 30. Submit that. Yes. Next.
Much obliged, lord.
Number 18. Ingoji.
My lord, petitioner before this honorable court questioning the action taken by the respondent, drawing up a high extension electrical wire mill from changing it to 220 kV to 400 kV, my lord, which is a without consent of the petitioner, which is a clear violation of the section 67 of the Electricity Act.
Is required?
Please, my lord. May I
Let us
read?
see.
Section 67.
Lord, we are not installing, Lord, a tower. There are, Lord, two towers are, Lord, already erected about 50 years back in the land of the petitioner. Now we wanted to replace the line, my lord, by fixing new line, my lord. The existing line has to be removed by fixing a new line. For this, my lord, the petitioners are entitled for damages as provided under the Act. Lord, they consistently this honorable.
He is saying that he has a right to object it.
Please.
That's why I want to know under which law.
Please. My lord. Section 67.
No, it
sub-
is governed by the Telegraphic Act.
Yes, yes. Lord,
But
Lord, before
that Electricity Act applies, my lord. Of section 67 subclause 2, my lord.
Lord,
The
before that,
appropriate,
Lord, one moment. Before that, I'll make one submission. For new installation, my lord, that is a different thing. It already installation is there. Now only changing, my lord, line, Lord, for consent, this the petitioners does not arise. But
He's relying on something. Let
Please,
me
please.
see. Yes.
my lord, section 67 subclause 2.
Subclause.
2. The appropriate government may by rules,
First, let us see 67. What 67 says?
please, my lord, provision to opening up of street, railways, etc. A licensee may from time to time, but subject always to terms and condition of his license within his area of supplies of transmission or when permitted by the terms of his license or lay down or place electricity supply lines without the area of supply. without the area carry out works such as. My lord, subclause 2, my lord, please. The cases and circumstances in which the consent in writing of the appropriate government, local authority, owner or occupier has the case may be, shall be required for carrying out works. My lord, section subclause 2 subclause H. The local authority means the municipal corporation, municipal councils, town panchayat, jilla panchayats, taluka panchayats and gram panchayats.
Where are you reading?
My lord, definition.
67?
My lord, no, my lord. From definition, section 2, subclause H, definition. Local authorities means. Who are the local authorities?
Definition of section 2, my lord, he is reading.
Please.
Yes.
Local authorities means the municipal corporations.
Find under 2?
H.
2H. Yes.
Means municipal corporations, municipal councils, town panchayats, jilla panchayats, taluka panchayats and gram panchayats. Here gram panchayats and taluka panchayats comes, my lord. My lord, and here without the consent, my lord, 67 subclause 2, my lord, where local authority, owner or occupier. I am the owner of the land. Without my consent, they are drawing the lines. Nor they have obtained from the local authority, nor they have obtained the permission from me, my lord. And I would like to submit a judgment.
But I have gone through the judgment, my lord. It says, my lord, they are
My
entitled
lord,
for
please.
damages. And in that case, my lord.
Page number 2.
In that case.
Para number 4. My lord, in the chart, there is a chart, my lord. For 220 kVA, 35 meters required, my lord, and 400 kVA, 46 meters required. My lord, when there is a increase of the meters, the electromagnetic field of the which is in the land also increases, which damages crops also and land of the petitioners also. This being the case, they have not taken any consent. They have not.
Don't dispute the fact that already there are lines running
Please,
through
ma'am.
land.
Please. But for the change of the line, there must be consent. Now they have already put the 220 kVA. There is no objection for the 220 kVA. But for the 400 kVA, they have to take the consent.
No, if you don't want,
Please, ma'am.
don't give the consent, what will happen?
My lord,
I'm asking.
it's up to my lord's my lord. I have to pass the
No,
orders.
can you afford to say
Please,
that
ma'am.
I will not give consent for laying the lines?
Please, ma'am.
You cannot.
They have,
You
my
can
lord,
only
in the.
ask them to pay the compensation, whatever the compensation, whatever you call it.
Please, ma'am.
And now before doing it, there is an authority who will adjudicate it.
Please, my lord, photograph, my lord. This is exit, sir.
No, that's true. If you look at it, if it is earlier 200 K, 220 kV, width of the right way, it is in meters 35 meters.
Yes,
If 400 kV, it is 46.
Yes, my lord. There, in there, you have, my lord, taken, my lord, the approved from the competent authority for laying, my lord, this uninterrupted power supply to, my lord, the public.
Please tell the board.
Please.
Now, whatever is the earlier kV, is it the same one or it is more than that?
No, now it is increased.
Now, in that case, it says that what is the area that's required, then you have
No,
to.
area is not, my lord, increasing. The only line, my lord, you ask me kindly see, area we are not increasing.
Read it.
But I have gone through it.
Yes.
My lord. Area is only, my lord, just now, photo you ask me kindly see. The line, wherever when the lines are there.
The effect of that electromagnetic wave.
Then they are entitled for, my lord, compensation.
Yes. So for that, what you should do?
Lord, they have to make an application for seeking, my lord, crop loan and corridor crop damages.
Who is adjudicating? Who are you?
My lord, I would like to bring my lords
KPTCL,
to the notice.
If the amount, my lord, paid by the KPTCL is, my lord, lesser, then the statute provide for seeking enhancement before the district judge under section 16 of Telegraph Act.
So that determination, that exercise, when it will be done, after completing or before doing?
Not the company, we don't know what is the crop damages. Not let them make an a requisition. What is the damages he want?
For doing it in his land, you should tell him so that he shouldn't come to the court, isn't it?
He has not made any representation to the authority. Directly he made a writ petition without seeking any the claim before the authority. Directly filed a writ petition seeking a mandamus. But let them file an application, representation. We will consider within 2 months. In that judgment, 3 months time was granted. Within 2 months, we will consider and we will decide the whatever the.
Mr. Counsel.
My lord, I would like to submit a DC's
And
order, my
another
lord.
judgment, another judgment. The court consistently held that they are entitled for damages.
They are entitled.
Para 11, my lord, last line. In that case, my lord, they want my lord of the before my lord installation of tower, my lord. Para 11, last, my lord. The court says that it is a technical feasibility can't be decided by the court. Therefore, the petitioner has to approach the authority seeking a
Who
compensation.
is the authority under your?
KPTCL authority. KPTCL. Respond.
Who is that? Who is the specified authority to whom they have to approach? In case if the central government is doing, the district collector will
No,
take as per the Telegraphic Act.
Respond number 1, my lord. 1 and 2. Let them make a representation today itself.
What is that what is that he has passed on? Something he was passing on? the
My lord,
judgment?
that is not clear, but the DC in his proceedings has fixed the amount for which.
That we will not do it. That exercise this court will not do. What is the amount?
Please.
How much you are?
My lord, but
entitled?
I would like to bring section 10 of the Telegraph Act.
Yes. Where is that? Read it. Read it.
Please, my lord, section 10 subclause C, my lord. Expect has hereinafter provided the Telegraph Authority shall not exercise those powers in respect of any property vested in or under the control or management of local authority without the permission of that authority. In such exercise of powers confirmed by this section, the Telegraphy Authority shall not do as titled damage as possible, and when it has exercised those powers in respect of any property other than that referred to in clause C, shall pay full compensation to the persons interested for any damages sustained by them by reason of the exercise of those powers. I am entitled for compensation fully.
Nobody is denying. Where did you go? Why did you come to the court?
My lord,
You have to go to them. You have to ask them.
my lord, we
If
have.
any refusal on their
My
part.
lord, I would
One
like to
thing is-
bring.
No, one thing is correct. You can't stop laying of the lines. You are only entitled for compensation.
My lord, I would like to bring page number 14, my lord, please, of my writ petition.
Yes.
My lord, they have issued a notice,
Look
like
to you.
this kind of a notice they have issued, my lord. My lord, there is no such address by whom it is issued. There is no concerning authority. Where I have to go, I don't know.
No,
From
we
who?
will say who is the authority. You go and will ask them to whatever, determine the compensation within 2 months from the date of receipt of the copy of the order. And if you're aggrieved, they have a mechanism, they have an appellate authority. You can go before that.
My lord, fix a date, my lord, and a compensation is to be ordered. Cost is to be put, my lord.
Or what is to be?
My lord, they have taken up the work, my lord, without the consent.
All these things will be decided by the authority while computing the compensation. If they are not happy, you have the remedies. After exhausting all the remedies, then you can come to the court.
Your Lordships, I appear for respondent number 3.
Only after the compensation only they have to take place of the work.
Where it says, when it is required, they will lay it. It is not that before laying it, they should give, which provision says so?
My lord. Section 67 O, my lord. Subclause 2, O. The procedure of deposit of compensation payable by the licensee and furnishing of security. Such other matters are incidental and consequential to the construction and maintenance of the works under this.
Yes, please, no.
My lords, I appear for respondent number 3, just to assist this honorable court, my lords. Section 67(5) provides that the appropriate commission will determine any difference or dispute with respect to the compensation. 67(5), subsection 5, my lords. And the appropriate commission is defined in the definitions provision section 2(4) as the State Electricity Commission, my lords.
1 minute. The appropriate commission, while determining any difference or dispute in addition to any compensation, may impose a penalty not exceeding the amount of compensation payable under this section. Cause little damage, detriment and inconvenience may be and should make full compensation for any damage, detriment or inconvenience caused by him or by anyone employed by him. So according to you, who is the authority, the first respondent?
Respond. Not a what may say, not the respondable. 1 and 2, my lord.
Yes.
Both will consider 1 and 2.
The writ petition is filed, saying the following prayer. It is a case of the petitioner that petitioners are the absolute owners and pursuer of the land. The survey number 2 measuring 9 acres and survey number 3 measuring 10.6 acres post at Adabihalli village, Kukanur Taluka, Koppal district. The second respondent has issued an endorsement without mentioning the name of the petitioners or the date of issuance, purporting to state that in accordance with the public utility requirement and a government order, work is being undertaken for the replacement and strengthening of the existing 220 kV rake power transmission line with an equivalent HTLS conductor. The said transmission line originates from the 220 kV power substation located in Gadag city, Gadag Taluk, Gadag district, and pass through the 400 kV ferry power substation and 220 kV power substations, culminating at the 220 kV switching station situated at Lingapur village, Koppal Taluk, Koppal district, covering a total length of approximately 89.763 kilometers. The said endorsement further indicates that a tower relating to the aforesaid transmission line is to be erected on the petitioner's land, allegedly pursuant to the said government order. It is stated that the first respondent has started construction of the transmission, has started laying the transmission lane. The petitioners informally requested to cooperate with the construction of the tower and the laying of the transmission line on the ground that it is necessary for public utility. It is stated that in the event of the damage or loss caused to the existing crops or trees on the said land, KPTCL would disperse compensation as per the rates fixed by the government and the concerned department, including revenue, agriculture, horticulture, and forest department. Next, Land Council appearing for the petitioner submits that the respondent, without issuing any notice, without taking a consent of the petitioners, are laying the lines. Because of this, because of the activity that is taken up by the respondents, it would damage the crop and the land because of the electromagnetic waves. It is submitted that the respondents are bound to follow the procedure as contemplated under the Electricity Act 2003 and also under the Telegraphic Act. Land Council submits that the respondents, without determining the compensation, they cannot lay the line. Hence, there shall be a direction to the respondents to pay the compensation to the petitioner and then lay the lines. Land Council appearing to the first respondent.
Para 4, my application for vacating interim order, my lord. My contention.
By order dated next one, dated 16/7/2025. An interim order was granted by a coordinate bench of this court, granting stay of laying high tension electric lines on the lands of the petitioner. A vacate petition is filed by the respondent.
Respondent number 1 and 2, my lord.
Representing 1 and 2. It is submitted that where do you get that?
Para 4, my lord.
But
Para 4 of my lord, application for vacating interim order. Page 2. It is humbly submitted that there are two old.
paragraph number?
Paragraph number 4.
4 says filed by whom? Advocate for respondent number 3. Yes.
Please.
It is submitted that there are two old land council and a vacate petition is filed on behalf of respondent 1 and 2.
My lord, respondent 3 is also filed vacate stay.
Vacate petitions are filed on behalf of 1, 2 and 3.
Great.
The vacate petition filed on behalf of respondent 1 and 2. It is stated that there are two old existing towers on the land of the petitioner in tower number 296/A and 297. That these two old towers are existing since more than 50 years. The authorities are not removing the existing towers as the said towers are intact. However, they are required to replace the old drake conductor by installing the drake equivalent HTLS conductor so far as in the land of the petitioners are concerned. It is stated that these replacement of the old drake conductor by new HTLS conductor being carried out from 220 kV Gadak substation to 220 kV Lingapur switching station. It is stated that this activity is for the larger interest of the benefit of the public, including the petitioner. As the project is for the public purpose, for the benefit of the public at large, already more than 79% of the work has been executed. In view of the interim order, remaining development of the work has been stalled.
My lord, one submission.
Yes.
My lord, KPT cell versus C. Nagaraju, ILR 2010 KR 1735. In that decision, my lord, it is from this honorable court, it is held that before holding an work, compensation is to be paid.
Give that.
Please, my lord, I will.
In view of the interim order, remaining development of the work has been stalled. In the vacate petition that is filed by the third respondent, it is stated that the respondents are not erecting a new tower on the petitioner's land. And the only work that is being undertaken is drawing the HTLS conductor to the existing towers. It is the petitioner suppressed the fact that there is an existing tower. The respondent number 3 is carrying out this work under award letter dated 14/3/2024. It is stated that the consent of the landowner is not required under the Electricity Act 2003 and the other rules. Section 67 of the Electricity Act does not mandate obtaining consent from the landowner for laying transmission lines. Section 67(2) of the Electricity Act only require that before exercising such powers, the licensee or authorized person shall serve a notice upon the owner or occupier of such property. And such provision does not require obtaining consent. It is stated that when a notice is served under section 67(2), If the owner or occupier has any objection, such person may file objection before the appropriate authority. The intent behind section 767 is to facilitate the development of electrical infrastructure in public interest. It is stated that the respondents are in exercise of the powers under section 164 of the Electricity Act, and the respondents are bestowed with the powers which the Telegraph Authority possesses under the Telegraph Act 1885 with respect to placing of telegraph lines and posts for the purpose of a telegraph established or maintained. It is also stated that no orders can be passed stalling the infrastructure projects. Further, petitioners have an effective alternative remedy under section 67 of the Electricity Act for filing their objections. And if they are agreed with the compensation, quantum of compensation offered, they have remedy to approach the appropriate forum for determination. And without availing the such remedy, the petitioners have come before this court. Having heard both the councils have argued in line with the objection that is stated in the vacate petition. Next para. Having heard the councils on either side, there is a material on record. It is an undisputed fact that already there is an existing tower. Now they are carrying out
Not replacing
Replacement of the
old.
brake converter with the HTLS conductor.
Now they are replacing the old drake conductor by installing the drake equivalent to HTLS conductor. The first submission of the petitioner that the consent of the petitioner has to be obtained before laying the lines. That submission, this court finds no force. When the electric lines are laid in the larger public interest and for the developmental activities, the consent of the petitioner is not mandatory. However, he is entitled for a notice, he is entitled for compensation. Even according to the petitioner, he has received a notice, but the notice doesn't contain all the relevant details. Now, the petitioner approached the respondent 1 and 2, and whatever is the damage that is caused to the petitioner's land because of the activities that are carried out by the respondents 1 to 3, he can seek the compensation. The respondents have to determine the compensation, and if the petitioner is agreed by the compensation that is awarded, that is determined by the respondent, he has a remedy before the appellate authority. Who is the appellate authority?
District judge.
Before the district judge.
Under section.
Under section
16 of Telegraph Act.
Under section 16 of the Telegraphic Act. The petitioner, without availing all those remedies, cannot come before this court. Accordingly, this court is passing the following order. The petitioner shall approach the respondent number 1 and 2. There should be at least either of it, either 1 or 2. How will he go to both? Either it is 1 or 2.
He will receive, will get the approval from the respondent number 1. Therefore, let them make application.
The respondent shall make application to respondent number 1 and 2 by 10th of February.
Please.
10th of February, and the respondents within 2 months from February 10th shall consider the
1 month.
Huh?
1 month.
Please.
30 days.
Consider the request of the petitioner, shall consider the representation and pass orders in accordance with law. accordingly disposed of.
Grateful.
Yes, next.
Seal number 19. Sharath P. from Reddy.
I appear for the petitioner, my lords, in this matter.
And for respondent 192, my lords, in this case, amendment application of the petitioner is came to be rejected
It can be any urgency, it can be adjourned.
as per the court's convenience, my lords.
Yes, this is matter on 11th of February.
11th February.
Interim order earlier granted is extended.
Interim order extended.
My,
20.
my lords, till then, he may not precipitate, my lords, because the matter is.
You have an interim order.
I have an interim order, my lords, to not pass the final judgment in the OS till the disposal.
else?
My lords, the matter is being held every day, my lords, in the trial court.
Whatever is the interim order, you will have the
My
benefit
lords,
of it.
my lords, next Friday, my lords. Any shorter date, my lords.
List on 5th.
Obliged.
Much obliged. Seal number 20.
Yes,
Represent the respondent, my lords.
Interim order is already there.
Interim
My
order
lords,
is there.
this matter, my lords, this matter,
Yes.
the consumer court, my order, my lords, is challenged on merits, despite having equally efficacious remedy.
My lords, I am impugning the order on the ground that, my lords, there is no relationship of a consumer and a service provided between the petitioner and, my lords, the consumer
It
complaint.
is an order that is passed by a
District Consumer Commission.
How can you file it?
On the ground of jurisdiction, my lords, on the ground of
No,
jurisdiction.
that can be decided by the state commission also.
Appellate
No,
court,
my
my
lords,
lords, yes, my
here,
lords.
here, my lords, when the state district commission did not at all have the jurisdiction, my lords, I need not again, my lords, approach the state commission for the reason that, my lords, the judgment having been rendered without jurisdiction is, my lords,
So every
honest in the law.
authority know if when a panchayat officer passes an order without.
If it is
availing-
if it is
No,
without,
It is like that. If it is not an efficacious, why it is not an efficacious remedy?
the judgment, my lords, of the Honorable Apex Court in the case of Whirlpool,
I think
Whirlpool.
similar matter has come up on the last occasion. And
Yes,
I
my
have,
lords, on last week, my lords, your
then
lordship.
in that
Yes, my
case,
lords.
what is the
W-
order? Let us see. What he says is, in the EP, now, same matter.
No,
No, my lords,
different matter.
this is on merit, my lords, main consumer complaint, the order is being under challenge, my lords.
Yes. What is
Main
that order? Let's see.
consumer,
My lords, the order, annexure A is, my lords, the impugned order, page 16.
We can't entertain like this.
Lords, the reason is, my lords, they can, the consumer can go against, my lords, the society. I have no issues. So there is a relationship, my
My
lords, I have
lords.
not taken the money. Society has taken the money. The deficiency is on part of the society.
Why don't you go before the, no, execution is fine.
Execution
In
is filed. Yes.
Execution, why don't you go before the executive?
No, my
court?
lords, in the execution court, executing court is not allowing me to enter appearance, my lords, without making, my lords, some deposit of the amount. Now, non-billable warrant is issued against me. To recall that non-billable warrants, I have to deposit certain amount.
Society is the opposite party.
Yes, my lords.
Why would they execute it against you? That's
My lords,
very simple.
that is what is being done. Now, non-billable warrant is being issued against me.
As against all the office bearers of the society, the complaint was filed, my lords, at page
Can
number
that be done, my
70.
lords?
And the petitioner number 1 and 2 are the president and the president and the vice president. Out of these 7, my lords, that is office bearer number 3 to 7 have approached the state commission, my lords, by making the statutory deposit. Now, my lords, these petitioner, my lords, only to avoid the payment of 50% statutory deposit before the first appellate court, they have approached this honorable court, my lords, only to overcome the statutory mandate, my lords.
How can, no, how come they are the consumers?
My lords,
How can
the
there be a warrant against the governing body members of the, no, in the official capacity it is done.
Yes.
If anything
Yes,
has
ma'am.
to be recovered, it has to be recovered from the society.
Yes,
Who is
ma'am,
the
exactly.
authorized person to represent the society?
My lords, it is the president and the vice president, my lords. They are the office
can the
bearers.
No, no, no.
They
Lords,
are
the
the
act
persons, my
itself is
lords.
Who are you?
I'm the president. I'm the one of the directors. Now, my lords, if I may invite a lordship's attention to the act, Sauharda Act. This is, my lords, the society is registered under, my lords, the Karnataka Sauharda Society Act, my lords. Under the act, it is only the chief administrative officer, my lords, who can be sued or be sued by.
Yes, my lords.
Then how can you
How
go
the
against?
court can, how the court can pass such an order?
My lords,
No, where is the order? Let us see.
Please.
Yes, my lords.
Now, the order starts, my lords, at page number 16. If I may invite a lordship.
No. Let's look at the cost item.
Yes, my lords.
Yes,
Cost
my
item.
lord. Page 16 and 17, my lords.
16, my lords, the names of the complainants, consumers. 17, my lords, my lords,
Aadhaar
Niyamit.
represented by
represented, my
its
lords,
president.
lords,
How can you find such a complaint? Why would everybody be representing the society?
Yes, my lords. My lords, now, my lords, my statement of objections, I have produced the election result, my lords, which is declared by the Karnataka State Sauharda Federation, my lords. They are the official office bearers of the society. Depending upon whose advertisement, my lords, the respondents have invested the FD amount, my lords.
There is a cooperative society.
Yes, my lords.
All members in the cooperative society, all elected members will be responsible for any of the acts that done by the society in its official capacity, according to you.
Yes, my lords. Now, all the office bearers were made as a party and the liability is held jointly and severally, my lords. All the opponent number 1 to 7 are directed jointly and severally to make the refund of the FD amount, my lords.
no, my lords, may I for a minute?
We'll hear it.
My lords, date, my lords, may kindly be fixed.
My lords, granted is this is matter on 25th of February.
Obliged.
Yes, 21.
Still number 21. Santosh.
Yes.
My lord, here is the petitioner has challenged the order of directing the police to give protection, wherein there is no injunction on.
We'll hear it some other day. List the matter on 3rd March. Intermodal earlier granted is extended. Yes, 22nd.
Still number 22.
Yes.
Pin. Pin.
For respond number 2 in this matter. Undertake to file wakalat membership since the commissioner is on leave.
It is
so
submitted that Mr. R. Shangadi will file wakalat. Will file wakalat.
My lord, I appear for petitioner.
Huh?
I appear for petitioner. Matter is very short, my lord, and my friend may come on record. The respondent number 2, my lord, for whom my friend is representing.
But he needs to have instructions. Let him have instructions.
My request next week.
Yes, next week. Yes, next 23.
Some date may kindly be fixed.
It is a matter on 9th of February.
9th February.
Yes,
Please.
23. Look at it, any interim order is there extend. Yes, 23.
I appear for the respondent in this matter.
But I have received,
I have moved the petition.
I have received a statement of objections and vacating interim order. I require to file a rejoinder to this.
Served long back. The reason why I'm
When you file the objection or vacate petition?
Lord, it was filed last week, Lord, on 13th, Lord. On 13th, we had filed. The only urgency that we are pleading is, Lord, this is a tag tender. The tender is for cutting and extraction and transportation of the material.
Yes.
Lord, we have a tag tender where the purchaser is there. He has given a rate which is only valid till, Lord.
We'll have it on 29th.
Please. What may have it on 27th or 29th? 27th.
29th, I said.
Please.
29th.
Please. But I pray for extension of interim order.
Granted is extended.
Please.
Yes, 24.
Number 24, admission matter.
Admit final hearing
Session.
PCR.
Admit.
25.
Still number 25, Hanumat Reddy Saukar.
Same. 26.
PCR. Still number 26, Santosha Satyagidi.
In 26.1.
In connected matter, my lord, I am filing memo for seeking dispensation of notice to R1 to R3.
R1 to?
R3.
R1 to R3.
A memo is filed seeking dispensation of notice to R1 to R3. Dispense with at the risk of appellant. Admit post of final hearing call for the DCR. 27.
27, Anjaneyam.
Is also admit final hearing. Yes, 28.
My lords,
Number 28.
27, my lords. My lords, there is a connected company appeal pending before the division.
Along with that. Yes, 28.
Number 28, Matapati. SG Hiremat, BP Matapati. 28.
Yes, this is after 4 weeks.
4 weeks.
No representation. Yes, 30.
Number 29, urgency number 30. Hiremat.
It's a owner's appeal, my lord. It's a owner's appeal. Expiry order is passed. I filed a petition under 9 Rule 13 for revocation. That is dismissed.
What matter you're representing?
I am representing owner of the vehicle.
30 you called? 30. This is
Serial number
CPC
30.
matter.
Serial number 30.
CPC matter it is.
Petition seeking restoration, setting aside expiry order was dismissed by the tribunal. That is challenged here.
Is it MFA number 104168?
Yes, ma'am.
104168.
You are saying that it is under the Motor Vehicles Act.
Yes, petition under Motor Vehicles Act was allowed by the tribunal ex parte. I filed civil miscellaneous 3/25 for setting aside the ex parte decision.
Why you have not appeared before the court?
It is alleged that the summons were served on the grandmother of the appellant hearing. It is not proper, and hence he was placed ex parte.
Deposit 50%. Then only stay. Otherwise, no stay. Because you have not chosen to appear, why should we stay?
Hello, my lord, not served on the appellant.
That we will know. That we will know once the respondent is on record, we call for the TCR. We can't grant a blanket order. If you want an interim order, 50%. Or else notice.
Notice may be issued, my lord, but some portion may be.
No.
Not
50%. Because there is a judgment and there is an award. Yes, 31.
Please, madam, subject to deposit of 50%.
50%. It is submitted that the notice is not served. Appellant is the owner of the vehicle. There shall be stay on condition of depositing 50% of the amount within 6 weeks.
Please.
Number 31.
Yes, 31.
Number 31. Rajshekhar Arni.
Admit, file hearing.
Admit.
TCR. Yes, 32.
Number 32. Santosh Satyakadi.
This is matter for file hearing. Call for the records. No, don't say admit because the ECA matter. Yes, 33.
33. Lingesh P. Kattaman.
Same order.
Beneficiary appeal, my lord.
Same order.
Same order, my lord.
That batch of matters are there in same order.
R1 is, my lord, government, my lord, take notice.
In that order, that also will be there. S34.
Cell number 34.
Same order.
Same. Preliminary hearing matter, cell number 35.
This matter is pertaining to renewal of passport, my lords, covered by judgment, my lords.
Covered by judgment, kindly have it on 28, my lord. I seek instruction from passport authority. Otherly, they have produced the judgment.
Already you have asked for.
Yes, my lords. No, my lords, my lord, on that judgments, they have approached the Calcutta High Courts. Calcutta High Court reject that application, then approach that Supreme Court, my lords. Supreme Court allowed.
What did the Supreme Court do?
Supreme Court allowed, but they have to file as per section passport, section 6(2)(f). They have to file the approach the same court which the criminal case is pending. So the Calcutta High Court, the CBI case is pending. They have filed the application on that time that passport has expired. That's the right, my lord. That's 4.23.
In this case, everybody, even criminal case is pending, you are coming to the High Court only.
Please.
They are not going there.
I had approached the criminal court. I had filed application also. My application came to be rejected.
If it is rejected,
Yes,
what is the remedy?
And then I applied to the passport office. Yes, my lords.
If an adverse order is passed against you, an interlocutory application by in a criminal case,
Yes.
the question is,
No, my lords, because in this case as well, they had filed an application.
what they have done in that case is not the relevant.
Because writ
factor.
petition is itself
It's a
maintainable.
procedure. In a criminal case, how can that be a writ petition?
No, in this Supreme Court judgment also, my lords, a writ petition only
Well,
was
kindly
filed.
produce 4.12, my lords. The fact of 4.12. The fact of this, my lords, in this case, my lord, that 17, 10, 20,
I'll tell you, we are on a basic elementary principles of law.
Please.
In a criminal proceedings, a judge passes an order and that is amenable to writ jurisdiction under which law?
I'm not challenging that order, my lords. I am challenging the
Okay, then
endorsement.
when there is an order staring at you, independently, how can you
Because-
file a writ petition?
Because passport has to be issued by the authority itself, my lords. Authority has given an endorsement that we cannot issue your passport since there is a pending criminal case against you. That endorsement has been challenged before this honorable court, my lords. And the very same fact has been
What did you file before the criminal court?
seeking permission for renewal of passport.
Hmm.
The trial court held that
If
this
you
is not.
question that, in that can't you get an order with this judgment?
No, my lords, this is not a proper forum to approach for seeking for renewal of passport is what is been held by the Sessions Court. Therefore, my lords, thereafter endorsement was also issued by the passport office, which is.
So it is not seeking renewal. The court is, the authority are not renewing because it's a pending case.
Yes, please, my lords. The very same facts are there in this case, my lords, in the Supreme Court case on which I am relying.
27, my lords, please.
27. Cell number 36. Please.
Matter, my lords, collection of forest development tax, lords, which was covered by decision of this honorable court, as well as, my lords, matters which.
Please, your lordship, as matter is pending before the apex court, your lordship.
Please,
There is an order.
please, Your Lordship.
There is that order. What is the relief you are seeking?
My lords, the collection of FDP at the rate of 12%, my lords. My lords, which was held, my lords, ultra virus in the Rudragoda case. Following that case, my lords, this honorable court has passed many orders.
Subject to outcome of that order, Your Lordship.
Where is the order?
Order at, my lords, page number 80, 50, 49, my lords.
49.
Yes, ma'am.
No, where is that?
My lords, relevant portion is, my lord, at page number 52, my lords.
No dispute the demand for.
52, my lords. From the above, it's seen that the petitioners are challenging the demand and collection of FDT on purchase of timber from respondent.
To the outcome of writ appeal number and connected matter. Writ appeal, no interim order, no stay is granted.
No, in Supreme Court stay is granted insofar as refund of FDT is concerned. Collection of FDT, my lords, the intact, my lords.
In the present case also, they are seeking refund of the amount.
No, not refund, my lords.
First prayer is, first prayer refund.
Yes, I'll leave that. Also, my lords,
Refund.
no, refund I'll leave, my lords. No, I'll withdraw my. In another case also, my lords, honorable court following this judgment.
So far as first prayer is concerned.
Yes, please. Very similar order is passed, my lords, following the judgment.
Yes. The present writ petition is seeking the following prayer. It's a case of the petition that the petitioner purchased the firewood from respondent number 3 in the auction held from 19/8/2024 to 26/8/2024, totally amounting to rupees 3. That is 3 lakhs.
Yes.
1,908.65. And the forest development tax at 20% was also imposed as indicated in the tax invoice sale bill dated 25/10/2024. It is stated that forest department tax was introduced as per section 98A of the Karnataka Forest Act. Division of this code by order dated 4/10/2017 in Rudragowda and others was the state of Karnataka and others arising in WP number 43937 of 2006 and connected matters reported in AR 2008 Karnataka 1819 held that section 98A of the Karnataka Act is unconstitutional and has struck down the same. And the state has challenged the said order before the Honorable Apex Court. The Honorable Apex Court has only stated the High Court order dated 4/10/2017 insofar as refund is concerned. It is submitted that in the light of the above, there shall be a direction not to levy. And there may be direction as prayed for. Learned HCGP submits that the Honorable Apex Court had stated the refund of the forest development tax collected from the petitioner. As such, the prayer number 1 is not maintainable. As far as prayer number 2 and 3, prayer number 2 is concerned, she does not dispute the fact that several writ petitions are disposed of. Next, having heard the counsels on either side, peruse the material on record. As far as the first prayer of the petitioner is concerned, in view of the stay granted by this court, again, in the appeal filed by the government in B. Rudragowda's case referred supra, the petition is not entitled for any relief. As far as demanding and collecting the forest development tax in respect of the timber and other forest produces, auctions sold by the forest department in the government timber depots across the state of Karnataka are concerned. The demand, collection and refund of the FTT would be subject to the final outcome of CA number 3974 4068 of 2016 and CA numbers 3214 to 3271 of 2018 pending before the apex court, accordingly disposed of.
Disposed. Seal number 37. Sanjay S. Katgiri. Tell us daily.
37, I appear for respondent, my lords. In this case, my lords, I want to make a submission. My lords, already, my lords, the defendants herein have filed application for rejection of plaint that is set down today for hearing. My respectful submission only, my lords, after completion of that application, it could be taken. If the plaint is rejected, entire things goes. Here, my lords, my friend has challenged one IA, my lords, temporary injunction is vacated on the ground of non-compliance. And one more application came to be allowed, taking additional WS on the ground. If the trial court decides the application in favor of the defendants, my lords, this goes. Only my submission. Till then, this matter may be adjourned or a request only, that is.
Lord, so far as first writ petition is concerned, the additional written statement which is permitted to file, already they filed it, and once again they sought for withdrawal it, my lord. Without challenging that order, my lord, entirety new more than 26-page additional written statement is filed, as good as withdrawing the earlier written statement, my lord. That order is in the first case, my lord.
That rejection of plaint is.
No, rejection now subsequently filed, my lord. This writ petition was filed
Court
on.
is hearing it today.
No, that is matter pending, my lord.
Asking, is it the court hearing it
Yes,
today?
he told it, but that is filed, but that is not hearing till it is. Says section 15 of the Karnataka Society Registration Act, my lord. That matter.
Don't have time
Now,
today.
my lord, now second case, my lord, that would be important. For the moment, my lord, in second case, 37.1, my lord. That was the writ petition which initially was there. So, your lordships, I thought that the caveat or registry has earlier put up a caveat. So, I thought that should not mislead the court, my lord. So, this writ petition was filed. The second writ petition, my lord, may kindly see, the interim order was granted, and I have, during vacation, district court has granted. I have complied itself, the issues of process and everything on the very next day. I filed affidavit, my lord. Even then, without their application, the trial court has vacated that order, my lord. Pending, they should have filed under order 39.4 for vacation or variation, my lord.
Can't we hear it on 2nd February?
Yes, my lord, I would say kindly stay this interim order because it is a society for handicapped and these petitioners member and some of them are the board of management. They are illegally removed and they are doing all illegal activities, my lord. So I have filed there was interim order of status regarding.
2nd February.
2nd February.
Your lordships, no,
Number 38.
your second case may be, he don't appear as a caveat, my
No,
lord.
I appear
In the
under
second
the-
case, my lord, may kindly see, at least have it on 28th, my lord. 20,
29.
please.
Yes.
Seal number 38. Shivraj P. Mudhol.
Petitioner seeking a mandamus to, they have made a complaint and seeking inquiry, holding an inquiry under section 25. The petitioner filed a complaint that is pending, Lord. Representation is pending, Lord. I pray for the
8 weeks, your lordship.
8
8 weeks.
Lord, private parties are there, Lord. Notice has to go. Respond number 3 to 6.
Consider the representation not
Please.
required.
Please,
They will give opportunity to them also. if
Please, please.
required. The present petition is filed seeking the following prayer. It is the grievance of the petitioner that
annexures, Lord, C7, C2.
it is stated that complained by the petitioner seeking to conduct an inquiry as provided under section 25 of the Karnataka Societies Registration Act has been pending consideration. The second respondent, being the statutory authority, ought to have initiated inquiry regarding FI's financial irregularities and misappropriation of the funds of the third respondent, creating the documents, forging the signature of the petitioners by the fourth respondent. However, the second respondent, without colluding with the fourth respondent and political influence, no steps was taken by the second respondent so far. As the petition has come up before this court by filing the incident writ petition, the Leonard GP submits that they will consider the same in accordance with law and pass appropriate orders within a period of 8 weeks.
8 weeks.
The date of receipt of the copy of the order, by giving opportunity to all the persons who are affected.
Please, your lordship.
Accordingly, this court is disposing of the, accordingly, this court is passing the following order. The writ petition is disposed of, directing the respondent to consider the representation dated
25.
The complaint into
Dated 7/2/2025. Void annexary.
in accordance with law within a period of 8 weeks from the date
Please.
of receipt of the copy of the order. Next paragraph. This court is not proposing to issue notice to the other respondents as no adverse orders are passed by this court. And the respondent, the official respondent shall consider the representation by after giving reasonable opportunity to all the concerned public affected parties.
Please.
Accordingly,
Please.
all ayes stands. Yes, next.
Number 39, Chetan Gunwade. Chetan Gunwade.
Yes.
Notes application filed under order 21 rule 97 is dismissed in execution petition. Notes petitioners, my lords, are the purchasers from the judgment debtor 1. Notes
Then the EP is dismissed.
EP is pending, my lords.
What is dismissed?
My application as a third party obstructor is dismissed on threshold only on the count that I have purchased during pendency of the suit. But which portion of the property, my lords, the survey number 307 is a large land, out of which, my lords, I have purchased 1 acre.
See the order.
Please, my lords. Impugned order, my lords, relevant portion starts page number 24, my lords. May I read, ma'am?
How can you claim equities now having?
Well,
purchased the
equity,
property?
I'm not asking equities, my lords. It is a large,
Whatever hearing, why should it be given to you?
it is a large extent of land. Lords, I have purchased 1 acre. 1 acre, my lords, may I pass on this chart, my lords, wherein, my lords, what is the agreement of sale? Basically, it was a suit for specific performance. Decree holder had filed. That was decreed. Against that, my lords, EP is pending. And
File an application at 2197.
yes, my lords, I had filed. That is dismissed without, not to dispossess, my lords. I'm in possession of the
The
property.
pendant let purchaser.
My lords, it is, if I'm dispossessed, my lords, very purpose. If at all,
What is the course available to you?
I'm sorry, my lords.
What is the course available to you under being a pendant let
Lords,
purchaser?
I'm not at, though I am pendant purchaser, not this portion of the property. It is a large land, lords, out of which I have purchased. My lords,
You purchase.
my lords,
When did you purchase?
during pendency of the execution. Just because, my lords, I have not purchased this portion of the land. My lords, may I pass on the chart, my lords, which, my lords, lords, these first 2 columns, my lords. Judgment, decree holder is claiming over the property.
Is suit scheduled property or not?
No, my lords, according to me, it is not a suit scheduled property. Court ought to have, my lords, examined whether it is suit scheduled property or not. Without examining this aspect, directly court.
According to you, from whom you purchased?
Lords, I have purchased from the judgment debtor only, but not this portion of the property. My contents.
Say that.
Lords, boundaries and extent are different, my lords.
What is the extent he is having?
My lords, 1 acre out of 1 acre 17 guntas, which is my portion. Decree holder is claiming, my lords, in 307 A bar 1, 1 acre 21 guntas, and 307 2 acre 17 guntas. My survey number is 307 bar 3.
What did the decree, what did the JDR say? Where is the document?
My lords, I have produced sale deed, my lords. I have produced sale deed. Court did.
Let us see your, that petition under 21 rule 97.
Not it is in, everything is in Kannada. Everything is in Kannada, my lords.
Because the court gives a finding that, at least what is your case? That we have to understand from the pleadings. Where did you say so? That this property and that property is not one and the same? From the order.
My lords, order, my lords, nothing has been examined. The court directly comes to the conclusion, my lords, may I read operative portion, page number 24, my lords.
Yes.
Reasoning starts. This execution petition was filed by the DHR against the JDR for seeking relief of execution of decree passed in OS number 11 of 2014 for execution of registered seal deed and handing over of the possession of the suit property. After issuance of notice.
Come to paragraph number 2.
2, my lords.
Yes. Page number 22.
Please, my lords. In the accompanying affidavit filed along with the application, applicant has deposed that 1 acre land has been purchased by the deceased Kanakamma out of the suit property.
Your case itself is that
Lords,
You
advocate.
you purchase the property.
It
Notice
is
to
mistake of the advocate, my lords.
Yes.
Seal number 40.
Notice.
Notice. Seal number 40. Shield 1. Check.
Yes.
The petitioners are the defendants, my lords. Plaintiff files a suit for partition in separate possession. Ex parte interim injunction was granted on I number 1. Subsequently, they file an application not pressing that application. Again, after 2 years, they file an application seeking not to alienate the suit property. That came to be allowed. Now, against that, there are 17.
Maybe you are alienating the property now.
No, not alienating, my lords. But same court that cannot once they are stopped from filing application, same application. Once they have withdrawn the application, my lords, it is at their instance application was withdrawn.
What was the reason for the withdrawal of that application?
They simply say do not not pressed.
Where do you get that?
Order is at page number 60, page number 48, my lords. 48. Order dated 16/9/2022. 48, there is correction in the order date, my lord, 16/9. This case advanced in view of the advancement application filed by the counsel for plaintiff, plaintiff number 1 present. The counsel for the plaintiff now present, not by memo regard to I number 1.
Here an application is filed seeking injunction restraining the petitioner from alienating the property and dismiss the same. Now after 3 years, again the application is filed and the court has granted the injunction and the court has no power to entertain the same. Considering the same, we shall be stay all further proceedings. The petition is permitted to take out hand summons on the counsel according to the respondent and shall file a memo to that effect. The memo shall be filed by 18th of February or else the stay granted by this court stands vacated. Next.
Number 41.
Please appear for petitioner, my lord. This matter, my lord, petitioners are the members of respondent number 5 cooperative society. Now, wide annexure, my lord, they are earlier managing committee.
Let's see the order.
Yes. Page 16, my lord, is the election, date of election, calendar of events. Your lordship puts at page point 9. Tomorrow is the date of election. Now, page 18 onwards is the list of ineligible voters. May please, your lordship may kindly see page 17. Page 17, point number 9.
To quash the ineligible voter list.
Yes,
dated 4/12/2025.
Yes. Now, this is in violation of Rule 13D of the Cooperative Societies Act, which clearly.
Okay, what are you doing till the elections come on?
No, notice was not issued. The Rule 13D specifies that clear 15 days notice to all the ineligible voters have to be given. Objections have to be called for. Thereafter, the respondent number 5 has to decide whether they are eligible or not.
You say?
The respondent number 5 is the society.
The disputed facts, your lordship, wherein the recent judgments also in our court. In our court also, your lordship, in coordinate benches, they are declined, your lordship, to give the voting rights. As they are ineligible list, your lordship, they are stated, their names were there, your lordship. And if any
Coordinate
disputed
bench,
facts are there, your lordship, then they have to approach under 70, your lordship.
My lord, a coordinate bench, my lord, has permitted to cast the vote subject to outcome of the writ petition. And also the another judgment.
That's why you are waiting till the.
No, your lordship, if they had issued notice, my lord, we would have deliberately, my lord, paid the amount. The issue is.
When did you come to know?
Yes. Now, this after issuance of this calendar of events on, my lord, 3/1/2026, we come to know, and immediately, my lord, we obtained the ineligible voters list, and we are not challenging the election, my lord, we're only seeking right to participate in the election and put the votes. Now, this honorable court in various cases, my lord, has held that's the right to vote and participate in the election process is a mandatory requirement, and Rule 13, my lord, of the cooperative societies is a mandatory rule. Rule 13D is also. My interim prayer is only to permit me to vote.
Come to the petition. Where did you say about? When did you come to know about this?
Yes. Para 6 onwards. It is submitted that there is no lapse on part of the petitioner in view of the fact that no such notices were issued to the petitioner. The petitioners having regular transactions
Where
with
did you say?
my lord, para 6. My lord. Para 6 of my petition. Para 6 and 7.
Which contemplates notice?
Yes, Malord.
Which contemplates notice? Which
Rule
provision?
13. Rule 13. Rule 13D of Malord, Karnataka Cooperative Societies Rules 1960, Sub Rule 2E. Yes. 13D, Malord. 13D, if your lordships have the same book, page 295. May I pass this one? There are two classifications of ineligibility under Rule 13D, Malord. One, if they don't attend the meetings for 3 occasions, and the other one is if they fall short of the any amount due to the society. The present petitioner's case falls under 3, clause 3.
13D.
Yes, 13D, sub clause 3. May I read, Malord? The election officer, your lordship. Both clause A and B are violated.
Where it speaks about notice to you.
Yes, may I read, Malord? Rule 13,
Yes.
3. Election officer shall stay. May I read, Malord? Election officer shall take steps.
So you're reading
13D.
Rule 13D, sub clause 3. May I pass this?
Yes, yes.
May I- The election officer shall take steps to publication of the voters list in the following manner. For publication of draft eligible voters list, a list of defaulters, a list of members whose repayment falls due before the election date, clear 15 days. For calling objections, if any, calling upon the defaulter members to repay the amount due to the cooperative society on or before 30 days, clear days prior notice to the date of election.
The petition is declared as an eligible voter. The voter list is published. Before the respondents have failed to follow the procedure contemplated under section 13(3) of the Act, no notice was given to the petitioner. It is submitted that election is going to be held on.
Tomorrow, Malord, 24/1.
Going to be held tomorrow, considering the submission of the petitioner and the fact that there are no notices issued to them. The respondents shall permit the petitioners to cast their vote in the elections 24 to be held on 24/1/2026. Then they shall not declare the result because
They
whether
can
you're
declare.
eligible. They will start the
Separately.
proceedings. That's how it
No,
happens.
there is no this thing for declaration of results. They will be kept in a separate ballot. Our votes will be kept in a separate ballot.
The said votes shall be kept in a separate box.
Please. May I request for hand
Notice.
delivery of the.
Lordship, notice, I'll
Yes,
take
notice
notice
to
for
Malord,
respondent
1,
1, 2, and 3 only.
First respondent, you take notice, first and second.
1, 2, 3, your lordship.
1, 2, 3 state.
SCGP takes notice.
4 and 5 notice.
5. The petition shall take out hand summons and file a memo to that effect.
Please.
List this matter on 29th.
Please. My lord, may I request for hand delivery of the interim?
This hand delivery of the order is permitted.
Please, oblige.
40? Yes.
The defendant is in before your ladyship. My lords, suit is filed, my lords, by the plaintiff seeking only the relief of my lords bare injunction on the strength of an unregistered seal deed. Trial court rightly dismisses his application under 13(1) and 2. The first appellate court, my lords, has erroneously allowed the appeal. May I invite your lordship's attention to page 28, my lords, para 28 of the first appellate court's judgment. Para 28, my lords, page 28.
Yes, please read.
In the instant case, the revenue records stand in the name of the plaintiff since from purchase of the suit scheduled property
When was it?
on the basis of
Purchase of the property is which year?
purchase of the property, my lords. 2003.
So right from
Sorry, my lords,
2003.
2010. 2010.
So right from 2010, the revenue records show that it reflects his name, plaintiff's name.
On the basis of an unregistered seal deed.
It is not a declaratory suit.
No, that's my that is my main defense. When my lords unregistered seal deed cannot confer any title, bare suit simpliciter for injunction could not have been maintained, in itself is not maintainable without seeking the relief of declaration. Unless and until he seeks a declaration that, my lords, he is owner.
According to him,
Please, my
what is the defendant is the owner of the property?
No, I'm, my lords, the defendants, someone, defendant number 2 is the owner of the property. I am now, my lords, the purchaser of the property subsequent.
Now, what is the case of the plaintiff?
Plaintiff that he is the owner of the property under the unregistered sale deed.
Who has executed the sale deed?
My lords, defendant number 2, defendant number 1, sorry. Defendant number
And number?
2.
Who are you?
I'm, my lords, the mother, I'm the son of, my lords, the original owner of the property. Defendant number 1's mother has alienated the property in favor of the plaintiff is his case. Defendant number 1, as a power of attorney holder of my mother, has alienated the property in question.
Now, both of you have filed your written statements
Yes, ma'am.
denying the title of the plaintiff.
Yes, my lords. And the trial court, my lords, precisely observes that the suit itself is not maintainable without seeking the relief of declaration.
The suit is filed by the respondent number 1.
Please.
Seeking injunction against the petitioner and respondent number 2.
3. Respondents 1 and 2 have filed the suit.
1 and 2 have filed a suit against the petitioner and respondent number 3.
Please.
Respondent number 3 seeking injunction. It is a case that the respondent number 1 and 2 have purchased the property from respondent number 3.
Yes, my lords.
Respondent number 3 by way of an unregistered
Sale deed.
sale deed. And basically, the trial court had dismissed the IA that's filed for injunction, whereas the appellate court reversed the same and granted the injunction. It is submitted with the land counsel, for the petitioner submits that when the petitioner has filed when the respondent have filed a suit for injunction, when the respondent plaintiffs have filed the suit for bare injunction, and the defendant have disputed the title of the respondent, disputed the title of the plaintiff, the court ought not to have granted injunction, as the bare suit for injunction is not maintainable in the light of the law laid down by the Honorable Apex Court in Anathula Sudhakar's case. Considering the submission of the land counsel, they shall be stay of all further proceeding. Pursuant to so and so.
I'm taking C of the order passed by the first appellate court. Please.
I said that only.
Please. Oblige.
Pursuant to the order dated so and so.
Please. Oblige.
Yes.
Appear for petition.
Yes.
Also, the petitioners are the members of the Murder Respond number 6 Cooperative Society.
Yes.
Now, Murder, they are seeking permission to cast the votes in the election, which is scheduled to be held on 25th of this month. But the impugned voters list came to be published by the returning.
Same society.
Same,
with the
same,
earlier
ma'am.
petition.
Serial number
No,
41.
my lords, one submission, my lords. As per the, my lords, in last case, my lords, we have issued the notice.
In this case?
In this case, but before 3 months, my lords.
No, they are
That
not
is our
issued the
notice.
notice to all the petitioners. My lord,
Below
let
3
him
months,
produce.
subject to, my lords, this honorable court also dismissed the writ petition 17756/25. This honorable court kind of grant interim order, subject to, my lords, so that's kept in the same, my lord, please.
Like in
And
the
date,
earlier
please,
matter,
please,
both the matters I'll hear it on the same.
please, my lord, please.
Same like in the earlier.
Please.
Government advocate appears for Respond number 1.
That's what.
Please.
Same.
I am for respondent number 6, my lord. My name is not shown in the
Number 6.
6, my lords. Yes, ma'am.
File the
Yes, caveat.
caveat. Yes.
Respondent number 6.
And deliver.
Appear in the other matter also.
Illa.
That
Yesterday
society is
matter, my
different.
lords.
That
This is
society
the
is
yesterday matter. It's
No,
listed.
society is one and the same. I'm
No,
asking.
No,
different.
no, no, it's a different.
May I request for hand delivery?
Oh, yes, handle it.
Section is
Yes,
on
next.
same.
Yes, next.
I'm member of the respondent number 6 society, lordship. Kindly bear page number 12, lordship. It is a calendar of event. One dated 12/1/2026, lordship. Annexure B. Annexure C is a provisional list, lordship, which is dated 13/1/2026. Annexure D is a final list. It is a very same day, lordship.
What is this direction? Directing the respondent to conduct the election to 6 respondent society on 28/1/2026 to quash the final voters list.
Yes, lordship. Without giving any objection to very same day, they filed final list and the provisional. Both are dated 13/1/2026.
So now the election is, date is not fixed.
It is fixed on 28th Lordship.
28th.
8th, this 28th only.
This is matter on 27th. You get instructions?
Please,
First, or respondent 1 and 1, 2, 1, 2, you take notice.
Please.
HCGP takes notice. 2
One.
and 2 to 5. For 2 to 6, then counsel the petitioner shall take out hand summons and file a memo by the next date of hearing. Yes,
Please, Lordship.
45.
Serial number 18 and 45 and 46 are same.
45 and 46 are same.
46 and 45 and 46. My lord, this is with respect to drawing of a high extension electric line over the petitioner's land.
Same like
Please,
the other
my lord,
matter.
please, my
Who
lord.
was the advocate appearing in that?
Mudod, sir.
So and so for both the advocates like.
Please, my lord,
whatever is there.
I would like to bring one more thing.
No, we will hear it. We'll hear it once let the names be printed. We'll have it on 29. This
Please.
is matter on 29. So and so. Give
Till
those
then,
names.
stay my kindly.
For the.
Stay
No,
my.
no, I'll dispose it off.
Well,
Respondents 1 and 2 and so takes notice. Respondent 3 so and so takes notice. We'll hear the matter and dispose it off on that day. This is matter because same order.
please,
Same
my
order.
lord, I would like to bring one more thing.
That day I will record, not now. List the matter on 29.
29.
Yes, next 47.
Abhilash.
Bill number 47. Vadiraj.
Petitioners are the judgment debtors, my lords. And the DHM respondent, my lords, have filed execution petition. And the petition number 1, my lords, is a borrower. He, my lords, alleged to have taken the loan of rupees 23 lakhs in their 2023, my lords. And in their 2004 only, the hypothecation agreement came to be terminated, my lords. Subsequent to it, my lords, arbitration award is passed. Subsequent to it, the execution proceedings are passed, my lords. And in execution proceedings, attachment of mobiles is ordered for.
Come to the order.
Please, ma'am. My lords will find at page number 19, my lords. Attachment of mobiles issued against judgment debtor 2 returned unexecuted with an endorsement as no valuables found. Advocate for JDR number 1, my lords, who is the petition number 1 herein, file objection, sufficient time given. No, it is not filed, my lord. Page number 20.
20.
Please. Page number 19 minutes, 21 minutes, the operative portion. Attachment of mobiles issued against JDR number 1 returned unexecuted with an endorsement as door lock. Subsequently, the petition number 2, my lords, who is the JDR number 2, filed obligation for setting aside the ex parte order, my lords. It was dismissed. And in that, my lords, attachment of mobiles was issued against petition number 1. And the arrest warrant is issued, my lords, against petition number 2, my lords. Wherein in the year 2024 itself, my lords, the hypothecation agreement came to be terminated, which my lords will find at 25, my lords, page number. After terminating the hypothecation agreement, they initiated the arbitration proceedings, my lord.
You have not contested.
My lords,
You were not a party.
I was a party, my lords.
Then what happened to the arbitration?
No, my lords,
proceeding?
after I was not aware, my lords. The reason is after the hypothecation of termination, they told that, my lords, hypothecation.
In that they have shown you as a party.
Please, my lord.
Notice is not served on you.
Notices, my lords, was not served on me, my lord. That was the reason, my lords. After hypothecation, I went to it, my lords, and I paid substantial amount, my lords. And they have terminated the hypothecation.
After the hypothecation agreement is terminated, and the respondents have initiated the arbitration proceeding without notice to the petitioner. Order is passed, and now the impugned order is passed. To break law, that's it. Where is the arrest warrant? Oh, issue. The court has issued arrest warrant and also directed to break open the lock, put to the house of JDR number 2, subject to payment of charges. Considering the submission, stay. The petition shall take out hand summons from the counsel appearing for the respondent and file a memo to that effect by 19th of February. If the memo is not filed, stay granted with this court stands vacated. Yes, next.
Number 48. Chetan Manwal. Seeking mandamus, my lords, to the trial court to dispose of the applications filed by me.
Which are, when are they filed?
My lords, they were filed on, my lords, 10/11/2025. What had happened is the dispute is with regard to temple, my lords, trusteeship. My lords, I had filed a suit on the very same day without notice and without any caveat. Defendants appeared suo motu. Thereafter, matter was heard at length.
when the matter orders were about to be passed, presiding officer was deputed to training. Thereafter, now matter is being listed before the in charge court, and I have filed an application for taking the gold ornaments deposited before the trial court.
No, won't they require minimum time for hearing the matter?
Why I'm insisting is because, my lords, or from 20th February to 23 February, there is a Vardanti Utsava, for which, my lords, I require these ornaments which are deposited before the trial court. That is why, my lords, I am.
The Vardanti.
My lords?
When is that? You're referring some date?
Yes, my lords, 20th February to 23 February. The Vardanti Utsava is there. And, my lords, my injunction application.
Did you file the application?
My lords, 10/11/2025, my lords.
What is the stage now?
My lords, hearing on applications.
Suit is of which year?
2025 itself, my lords. On the very same day, along with the.
Where is your application?
My lords, first application 39(1) and 2, IA number 3 and 4, annexure D, my lords, page number 115. These are the injunction applications. And IA number 7, for release of the gold, annexure H, my lords, page number 151, IA number 7. And police are, my lords, they are colluded with them. When I approach the police station for registering complaint against them, they give.
Where is that? As far as this application is concerned, we will, that February 1, where is that IA?
My lords, annexure H, my lords, page number 151, my lords. My lords, even, my lords, for this also, injunction application is also necessarily required to.
They require them reasonable time. It is not that you have filed it long back.
What had happened is,
When the defendant appeared, when they have entered appearance.
very same day, suo moto they appeared without any caveat. For that reason, my lords, my ex parte order also, opportunity is also lost, my lords.
The present petition is filed. Seeking the following relief.
Page number 39, prayer, my lords.
It is submitted that where is that, just now, there is urgency in this matter.
My lords, page and February 20th to 23rd.
Date, where is that?
Invitation annexure J, my lords.
Page number?
162. I have enclosed the invitation copy
It
itself.
is stated that, something in the application you have stated, where is that? It is in Kannada.
Annexure H, my lords.
Page number?
151. For release of.
It is stated that for the purpose of conducting the Vardanti of Shri Mudri Shivamma Devi between 18 to 2026 and for 24 to 2006, and also during the Dasara and Pallaki Utshav in the month of October 2026. They filed the application. It is submitted that in view of the urgency, there may be a direction to the court to consider the IA numbers 3 and 2, considering the reasons stated, there shall be a direction. The so-and-so is requested to consider these applications as expeditiously as possible, but not later than February 5th. How can they do? It's already there in December 27. Today is January 20.
January 27.
How can they do it in such a short span?
It is.
For a minute, I was thinking we are in December.
It is already my lords.
February 20th.
20th, my lords. February 20th, my lords. If at all, if I get.
February 18th.
Notes. 18th, sir. Notes. I number 3, 4, and 7.
Yes.
Please, notes. Obliged.
If whatever is the urgent IA that has to be, if 3 and 4 are both are necessary for that day, then both to be considered, or else only the IA pertaining to that February 20th to be considered.
Yes, please.
Yes, next.
Obliged.
Bill number 49.
Lord, 49, 50 and 51. The surety is challenging the auction come sale, my lord, by the respondent number 2. 51, my lord. The only ground, my lord, is auction. The surety is challenging the auction come sale. I am the surety, my lord. The only ground is the land has come under the acquisition. Even for by the consent award, the value of the property is much more, my lord. So they have valued it quite much lower than that. Now acquisition, if I get the amount from the acquisition, I undertake to pay back the amount. The moment I get the amount from the acquisition proceedings, till then.
Where is that moment?
Please, my lord.
When is that moment?
My lord, anytime soon after the budget, my lord, I am expecting the amount, budget after the state budget, my lord. Some percentage amount may be permitted to pay, my lord.
Your Lordship, notice was issued on 4 December 2025 itself, Your Lordship. On or before, it was noticed that it is going to auction. If at all they are aggrieved, Your Lordship, they should have
I have placed the
make an
JMC report
arrangement.
in one petition. I have placed the JMC report also, my lord. The property worth about 9 crores.
We'll see. List on 3rd.
No, 29th, it is scheduled for 29th, my lord. Auction aguduthu. My petition.
28.
Please.
28.
Take
Without a
notice.
reason, without any bona fides, without an affidavit, nothing, I will not pass any order. I'm making it very clear.
Notice, Your Lordship, I'll take notice for respond number 1.
Takes notice on behalf of the respondent. Yes.
Bill number 52.
Well, appeal for petitioner. Petitioner had filed suit for partition and separate possession against respondent number 3 to 5. My lord, a compromise decree was passed in the Lok Adalat. My lord, thereafter, my lord, after 1 year, the bank tried to interfere my possession. So residential house was allotted to my share. I filed a suit for injunction. My lord, my suit for injunction was pending. Therefore, they filed an application for rejection of my plaint. My lord, the application was allowed. Against that, my lord, my appeal is pending before lower appellate court. Rejection of plaint amounts to decree. Therefore, I had filed an appeal. Appeal is pending. My lord, when during the pendency of appeal, my lord, this respondent number 1 bank, including my property, my lord, issues a sale auction notice. Kindly turn to page 108, 109. Lord, there are 3 properties which are bought for auction. I no objection for my lord auctioning the property at serial number 1 and 2. My lord, serial number 3, my lord, in page 109 is my house property, which is been brought to the sale. My lord, 2020, 14/10/2020 is a compromise. My lord, this notice, my lord, auction notice is issued on 1/1/2026.
Come to the impugned order.
My lord, impugned order, my lord. Madam, I have sought my.
Let us read the order so that the facts will be clear.
Madam, my prayer is to quash the proceedings pending before my lord appellate court. My lord, what has happened? The compromise decree, my lord, which was before the Lok Adalat, is challenged by way of filing a civil petition. Civil petition is the Supreme Court has recently said the civil petition or other civil remedies are not maintainable. As my lord, it is only the writ petition which has to be filed.
Please, you have to tell the court, it in the nature of certiorari.
Yes.
Calling for the proceedings in miscellaneous number so and so.
Yes.
Why you have no other remedy but to file a writ petition to quash this?
My lord, the bank filed a civil petition.
We have to do things which are known to law. Not
Well,
like
I'm
this.
saying that only, my lord. Bank files, my lord, civil petition. Instead of filing writ petition, files a civil petition.
Where is it pending?
Well,
Where is it pending?
it is pending before, my lord, the lower appellate court.
And then what you are supposed to do?
My lord, my RA is also pending there.
In that area, can't you ask this relief? When a comprehensive case is pending there.
Yes,
you have
I have filed, I sought for that also, my lord. I had, my lord,
having sought such a relief there, how can you file a writ petition?
my lord, now, during the pendency of appeal, this show cause, my lord, auction notice is issued, including my property in the, my lord, house property.
I think I don't have to tell you where you have to go. How can we interfere in this? Please tell.
No, I had made an advancement application. I moved an application there.
Yes, notice.
Notice. Seal number 53. Pin and the names.
Petitioner is an appellant before the first appellate court. For appointment of court commissioner, application came to be dismissed. It is only to differentiate the wall of his property. The wall actually belongs to his property.
Let's read the order.
Operative post page number 35, paragraph page, internal page 15, ma'am.
You are the plaintiff.
I am the plaintiff. My house property was built in the time immemorial, more than 100 years. The reasons are given at para 20, my lords. Para 20 of the impugn order. Dismissed only on the ground that, my lords, we cannot differentiate the wall
Where you have filed this application?
before the first appellate court.
And let's see, where is that order?
Sorry, my lords.
That order, page number.
Annexure D, page 56 is the,
Yes.
page 58, my lords. Reasonings have been given.
So now that is the only issue with regard to the wall that has to be decided by the advocate commissioner. Please read the reasoning part.
My lords, at page 58. Para 8, my lord, the advocate for the respondents relied upon so and so judgments. Their lordship observed that the commissioner report cannot be basis for concluding whether parties' possession of property or not for the purpose of granting temporization. That must be decided on the basis of evidence adduced by parties. In this case, also only appointing an advocate as a court commissioner to visit spot and see the wall and submit report is not helpful for to decide the case. This is the only reason, my lords. What
else reason you want?
My lords, actually the construction of my house property is 100 years old. The neighboring defendants have purchased.
This suit is dismissed saying that it is a common wall.
No, that is the difference, my lords. I have produced the photographs along with page number 60, my lords.
At what stage it is the appeal?
Sorry, my lords.
Appeal is at what stage?
Now it's for a final hearing as a last chance on 27th, my lords.
At that time you filed this application.
No, before that also I have filed, but it was now posted for a final hearing. That is, the house is constructed by my ancestor 100 years back. The neighboring landowner has, the defendants have purchased it from another owner. In the sale deed, he has mentioned that it is a common wall between both. His property is 376, mine is 375. And my house property is 100 years old. And wall is different, walls are there. He is having different wall and mine is different. Only to differentiate that. But I also sought interim order also because 27th is the for final hearing.
This is matter on 28th. 28. There shall be stay of all for the further proceedings till then. By the time the petitioner shall take put hand summons on the counsel for the respondent. This is matter on 29th.
Please.
Yes.
To appear for caveat respondent. For the bank or the auction notice is under challenge. Auction is scheduled to be held on 28th. May I request my lord to have this matter on 27th? Or meantime, I will produce certain documents and file applications. 28th is the auction.
Yes, there's the matter on 27th.
Please. Oblige.
Yes, 55. 55. Yes, list this matter on 19th of February. 19th. Look at it if interim order is there extent. 56.
In this matter, my lords,
Small submission,
appear for
Lordship.
respondent.
Lordship, kindly tag CN 50, 51 along with 49 lots. Kindly tag CN 50, 51 along with CN 49 lots. It's a
50, 51 along with 48, yes.
49.
49, yes.
56, my lord, I am appearing
Lords,
for
in
the
this
petition.
matter, my lords, earlier, my lords, on 15/12/2025, this court has directed to deposit the arrears of my lords maintenance. Still today, he has not deposited.
In
Day
fact,
after tomorrow,
Case 56.
56, my lords.
Yes,
My lord,
we'll
there
hear
is,
it-
my lord,
We'll hear it on 29th.
yes, my lord, interim order may
pre-
carry.
Interim order only granted is extended till
In
then
preliminary
57.
hearing. In preliminary hearing. Please.
Yes,
Seal number 57. Girish Yadva.
yes.
Girish Yadva.
Petitioners are the defendants, my lord, sued for possession alleging encroachment, my lords. My application for court commissioner is rejected, my lords. The present suit, which is based on the PT sheet that is produced in OS number 2015, my lords.
What is called is 57.
OS 75 of 2015, my lord.
She is representing you.
Please, my lords. My application for court commissioner is rejected, my lords. The present suit that is filed by the plaintiff is on the same basis of the PT sheet that is produced in OS 75 of 2015, my lords. The reasoning that the trial court gives is that I have not disputed the identity of the suit property, my lords, and that there is no necessity of the measurement, my lord.
The similar issue, one more suit was filed by this plaintiff
That suit, my lord, there are 5 properties. All the properties were, my lord, measured, my lord, by the court commissioner and report was submitted. That suit was decreed. Against that, that was, my lord, carried out in appeal by the, my lord, the petitioner. In appeal, my lord, including this property, this court has already decided, my lord, that he is not the owner of these properties, he has encroached.
Does this matter on second?
Yes.
Second. Yes, all these final hearing matters, give some date. Yes, interim order is there, it will be extended.
ಎರಡರೊಳಗೆ ಎಲ್ಲಿ
Connected matter ನಲ್ಲಿ ಮಾಡ್ತೀರಲ್ಲ extension. ಹೇಳ್ಬೇಕಾ?
ಇವು ಕೊಡ್ರಿ ಸ್ವಲ್ಪ.
Sir, 59. Sir, 59. 59 interim order extend ಆಗ್ಬೇಕು.
ಹ್ಞೂ ಸರ್.
ಎರಡು ಕೇಸ್ನಲ್ಲಿನೂ ಕನೆಕ್ಟೆಡ್ ಕೇಸ್ನಲ್ಲಿನೂ ಬೇಡ ಇದೆ. ಎರಡು
ಡೇಟ್ ಬೇಕಾ ಸರ್? ಡೇಟ್ ಬೇಕಾ?
ಏನು ಬೇಡ ನಡೀತದೆ.
Just after 2 weeks, interim order extended. ಆಯ್ತು ಮುಗಿದ ಬಿಡ್ತಾಳ್ರಿ, ಒಂದ್ ಐತಿ. ನೀವು ಮುಗಿದು ಬಿಡ್ತೀರಿ.
ಇಲ್ಲ, ಇದರಲ್ಲಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿದ್ದಾರೆ.
ಅರ್ಜನ್ $53. Stay till the next date of hearing. Stay 28/1. Hello. And some hello sir. Sitting ಮುಂತಿರಿ ಬಂದ್ ನೋಡ್ರಿ ಮೇಡಮ್. ಮಾಡಿದೆ ಅದಕ್ಕೆ ಒಂದ್ಸಲ ಮಾಡಿದೆ ಸರ್, ಆಗಿಲ್ಲ ಮಾಡಿದ ಮತ್ತೇನಂತ ಹೇಳ್ರಿ. ಹಾ ಮತ್ತೇನು ಈಗ ಇಲ್ಲಲ್ಲ, ಈಗೇನು ಇದು ಐತಲ್ಲ, ಇವತ್ತು ಬಿಸಿ ಐತಲ್ಲ.